Good morning, everybody. Happy Friday. Welcome to the Courtroom Files Live. We will start in Miami-Dade, where we normally see Judge Glazer, but perhaps she's getting some much-needed time off. We have Judge Maria Espinoza Dennis, who I know nothing about. Let's see what's going on.
Your Honor, Bruce Lear, LEHR, on behalf of Ms. Ramos. Also present is her entire family, parents, father of a child, her husband, the whole group.
Good morning, everyone. Okay. All right, this is Ms. Ramos? Okay. Good morning, ma'am. All right, I have an arrest affidavit that says that Ms. Ramos is accused of committing the following crimes. And count one is an aggravated battery on a law enforcement officer, which appears to be a first-degree felony. And count two is resisting an officer with violence to his person, a third-degree felony. I just saw this now, so let me take a quick look at the arrest affidavit.
I'll stipulate to a third-degree felony as to count number one. It should be battery on a law enforcement officer.
I'm sorry, I
Not
couldn't.
ag battery is what you're saying, correct?
Yes.
I was going to challenge the probable cause
Okay, well, let me take a look at it, just really, as to that count only,
as to that count.
on the reduced, or now that there's been a stipulated reduction.
Now
which
it's
is in-
a
it becomes a
stipulated
neat argument.
reduction, no more challenge,
Got it.
easy.
All right. So, Madam State, this would be standard. I heard there was an officer, did I not hear right, that wanted to appear on this?
If anybody's here on this case, can you please raise your hand on Zoom? Okay, let's see.
Was advised
There
by
is an officer who's present. I'm going to promote the officer, Judge. So Officer Sanchez, if you'd like to talk to the judge, you have to unmute and turn on your camera.
I apologize. I'm here for Martinez Jose.
Oh, okay. So no.
terrific, right. All right, so,
Would like to address the bond, however.
yes, go right ahead, counsel.
Thank you. My client who attempted to post bond yesterday immediately upon being booked was told she couldn't because they had checked the box of hold for bond hearings. Obviously, that was just a ruse to make her spend the night in jail. They also took a simple battery and made it an aggravated battery. With that type behavior, I would ask for an ROR. She's already been more punished than she should have been. She should have bonded out at around 2 o'clock yesterday, and indeed she tried.
The state's requesting that the court just set a bond.
I'm sorry, I can't hear the
We're
state.
requesting a monetary bond.
They're saying, the state is requesting monetary bond.
Your Honor, she's a 36-year-old with absolutely no priors. She's a real estate agent. She's lived since coming from Cuba at 4 years old in Dade County. She's no risk of flight. What she was doing was asserting her right to speak in the county commission chamber, and as such, she's certainly no danger to the community.
All right, Mr. Lear, I reviewed the arrest affidavit, and the arrest affidavit on four corners sets forth probable cause for the two counts that now have been reduced by stipulation with the state, which is a battery on a law enforcement officer and resisting an officer with violence to his person. So the court, based on that, is going to make a finding that there is probable causes to both third-degree felonies, and I'm going to issue standard bond in the amount of count one, $5,000, and count two is going to be $5,000. Both counts.
Count two already was 2,500.
They get set on a resisting,
Right? That's what it is, Judge. The print said it's 2,500.
corrected, and I see it here, 2,500. So count one is 5,000 and two is 2,500.
Thank you, Your Honor. It's good to see you again.
Likewise.
And
And good luck.
Thank you. I would just ask that the corrections reflects that Ronca bail bonds is going to post it because it becomes a free for all, unfortunately.
Okay, corrections, you got that?
Yes, Your Honor, but we cannot put that on the jail cards. You're just gonna have to post the bond.
You have the bond amount, 5,000, count one, count two, 2,500. Okay,
Thank you. Always good to see you.
likewise. Hold on, well, hold on a second. What is this that you're giving me?
Flores?
Okay, what is this?
Was the attorney.
Okay, and the attorney, okay, so this is Arturo Flores? Okay. And let's see what page that's on.
Also, corrections, when you have a chance, I'd like to call to Harino for the private attorney.
Yes, thank you.
Okay, so this is on page 7. I'm being told Arturo Flores. Is this Mr. Flores?
Morning.
Are you Mr. Flores, sir?
Yes, ma'am. Good morning.
Good morning. Okay, let's see what we have here. All right, Mr. Flores. Yeah. All right, you have a private attorney is my understanding. Yes? Did you don't see him?
Okay, I think it's Mr. Della Fera. I'm gonna promote him to a panelist.
Your Honor, he has a private attorney.
Yes, that's what we're trying to, I think he's logged on. That's why we
Good
were,
morning, Your Honor. Richard Delafair on behalf of Arturo Flores.
good morning, Mr. Delaferro. All right, I have your client here. My understanding, see here, I have an arrest affidavit that says that Mr. Flores is accused of having committed 1 count of battery on a person 65 years of age or older and 1 count of simple battery. And this allegedly occurred on January the 9th, 2024 in the vicinity of 3128 Northwest 88th Street in Miami. Okay. Let's see here. Victim number 1 apparently is the defendant's mother is what I'm reading here. And victim number 2 was, I guess, a former spouse of the defendant.
So, Judge, unless I missed it, I didn't see the age in the A form. And I will note that it does date back to January of last year. Counsel, do you know if the mom wants a stay away order?
Well, here's what I can tell the court and tell the state. In January of 2024, Mr. Flores contacted me about this incident. I learned that the mother and the former spouse had moved to Fort Myers. I contacted them there. They provided me with waivers of prosecution. I submitted them to the detective. We thought it was all over. 3 days ago, Mr. Flores finds out that they're looking for him. I called the detective that I had been communicating with 18 months ago, who said, well, I have to file something because it's domestic. So we arranged for Mr. Flores to surrender right away. We thought it was over. It's not over. And we do have waivers of prosecution. So another thing that I will point out, there is a woman, Mr. Flores's fiance. I know she's trying to get on Zoom. Her name is Yusmila Arancibia. She told me this morning that because I asked if there had been contact between Mr. Flores and either of the 2 alleged victims in this 18 months. And she says, yes, we go over there to see Mr. Flores' son all the time. We were just there in May. We got invited into the house. We were offered refreshments. So there's no, as far as I can see, there's no animosity here. This was an incident, Judge, where the
That's
family.
the point, counsel. We got it.
Okay.
This is, I'm limited to the 4 corners. Okay. Taking a look at this, I looked at the age, I pointed out the alleged relationship. However, and the state is correct. I now had a chance to take a look at the A form. It doesn't mention the age. So the state of Florida can do one of 2 things.
Judge, I'm not requesting a hearing.
Yeah, so that's what I needed to hear because they could always reset, bring in their police officer, and they don't want that. So the only thing I can do is find PC for 2 counts of simple battery. Okay, and what I'm going to do is I'm going to set standard bond on each of those, which will be $1,000 each because they are with force, and enter a stay away order. Okay, I don't have the authority. They're not here to tell me whether it's going to be modified or otherwise. So until such time as that takes place, and that may take place in division, forthwith, I have to explain to Mr. Flores that if he's able to postpone, part of the conditions of his release is that he can't have any contact with either of these 2 people, because then you'll be back in court again. So you cannot, first of all, you can't engage in any criminal activity as part of the conditions of your release. You can't use or possess any illegal drugs. You can't use or possess or carry any firearms, guns, weapons, or ammunitions. And if you have any, you have to surrender them to the police department and get a receipt for them and file it with the court. You're prohibited from having any direct or indirect contact with the alleged victims which have initials DM with a date of birth of February 20th, 1974, and 8H with a date of birth of 8/19. I think it's what it says, 1945. That's what it says. But that's a separate, this is this is a state order that was filled by the state of Florida, and that information is not contained as it relates to the victim with AH initials in the A form. That means no contact direct or either through email, telephone, social media. You understand that you have to stay away from both of these people, 500 feet away from their home, place of employment, or school at all times. Do you understand that?
Yes, ma'am, I do understand.
If you possess any personal items in either of the residences that belongs to either of these two individuals, you have a right to enter once with the accompanied by law enforcement officer so that you can retrieve your personal items. Understood?
Okay, but I don't live there.
He doesn't have any property there, Judge.
Okay, that is the case. All right, so that's the disposition. So a total of $2,000 is his bond. Okay,
Thank you for your time this morning, Judge.
thank you. Good to see you, counsel.
So while she's between contestants, good morning again, everybody. Welcome to the Courtroom Files Live. Working hard here. Most of our courts that I normally have an eye on are just now getting up and running, so paging through to see what all they've got going on. A little bit of a late start in a lot of places, but that's all right. So we're going to continue to ride with Judge Maria Espinosa-Dennis. Let me know in the chat what you think of her. We haven't seen her before, and we'll switch as appropriate as I find things.
You can write in the chat what you got so we can pull it out of turn for you.
Okay, bottom of page 18. Got it. Good morning.
Thank you, Judge, and thank you, State, for promoting me. Andrea Canill, Cunill, on behalf of Dr. William Tejero.
Okay.
I don't know if you can see him, Miss Eth, but Mr. Gaviria is trying to be present as well on his behalf.
Okay, I'll promote Mr. Gaviria.
Good morning, Your Honor. I logged on just in time.
All right, terrific. Okay, so my understanding is your client, William Tejeda, is in Ward D this morning. See, this was reset previously for today. Okay. The charges are that he's purportedly committed the one count of battery on an emergency medical care provider. Do both of you represent, it's the same office or?
Yes, Judge, we're both representing him. Our pleadings have not made it to the official file to be docketed.
Okay.
But for the record, it's spelled Andrea, Cunill, Frank Gaviria, Gaviria.
The state's just going to be asking the court to set a bond.
Thank you, Ms. F.
To the audio, I can barely hear now. It's very, let's see here, when they switched over to that screen.
Oh.
I'm sorry, Madam State.
Just thank you.
Just if I think he hasn't been able to post a bond, so if Your Honor would just set it so that he can post his bond.
Okay. All right, and this appears to be a third-degree felony, correct?
Yes.
All right, I'll set bond. It's a third-degree with fourth, so it'll be $5,000 with a stay away order.
Right, Judge, we can't do this daily order because he
We
can't
can't.
here to acknowledge it, but
I have to read it. I can't do it here.
okay. In division or at a later time.
Thank you, Miss Eth. I appreciate it.
All right,
Thank you, Ms. F. Nice to see you, Your Honor. Have a
Yes.
nice 4th.
I'm going to hang around. I just wanted to make sure the jail card has no holds.
I
And
have
that,
no, I have, this is, corrections. We have no hold. It's a $5,000 bond, correct?
Okay, all right.
okay, we'll have the family post it. Thank you, corrections.
All right, on page,
Welcome.
May I leave?
page 1 of the calendar, yes. Jessica Zambrana,
Zambrana may qualify for TAP.
good morning, Ms. Zambrana. I
Yeah.
appointed the Public Defender's Office to represent you.
Yes, ma'am.
appointment?
Okay, so there's PC, but my understanding she qualifies for TAP. So it'll be TAP with the alternate bond of 2,500. Okay, do we need to reset this for a report on TAP?
So she should be set for arraignment in approximately a month, so that would be July 30th in front of Judge Gamez in courtroom 2-3.
You got that, Ms. Zambrana? And she's gonna get this in writing, right?
Ma'am.
She's number 1.
Okay, what's your, well, because she's homeless. It looks on the A form.
And then that's why I got arrested.
So corrections, you're gonna set the arraignment date. I mean, the clerk will set the arraignment date, so now we've given her notice.
The arraignment date is July 28th.
Yep, so she's gotta come back to court on the 28th.
I got it. Not the 30th, 28th. Okay, so they're gonna give her this, is what I'm trying to say, before she's released. Okay. All right. Good luck, ma'am. Jacqueline Cordero.
She's a bond out, Judge.
Found out, so this is.
And Judge, Miss Gonzalez Perez is going to need the Spanish interpreter.
Thank you. All right, Mr. Interpreter, Miss Gonzalez, good morning.
Buenos días, señorita González.
All right, my understanding is that it is alleged that you committed the following offenses. One count of a deposit with an intent to defraud by way of a worthless check, 3rd-degree felony, and 1 count grand theft in the 3rd degree.
Pero usted tiene 2 acusaciones de delito mayor. Una, de hacer un depósito con lo que usted entendía que era un cheque sin fondos. Y 2, hurto en cuantía mayor, ambos delitos mayores de 3er grado.
This supposedly took place in a, let's see here, in a facility located at 957 Southwest 122nd Avenue.
Esto sucedió en una facilidad que quedaba en el 957 Southwest de la 122 Avenida.
On September 11th of 2024.
Sucedió el 11 de septiembre del año pasado.
She should qualify for pretrial.
La fiscal adjunta, la doctora F., está indicando que usted calificaría para el programa de intervención previa a juicio.
Is she the only one? Or any co-defendants with this? No, right?
No.
Su señoría está preguntando si usted es la única y si hay coacusados. La fiscal adjunta responde que no.
Ma'am, where do you live?
Señora, su dirección, ¿dónde vive usted ahora?
11100 Southwest 196 Avenida 33197. Es que hace poco no me recuerdo bien.
Ok, 196 Avenida. ¿Y el código postal lo recuerda?
Creo que es 33197.
97. ¿Y esto es casa o apartamento?
Un apartamento.
Apartamento número,
19.
permítame confirmar. 11100 Southwest de la 196 Avenida.
Sí, creo, es que es poquitico que vivo ahí, no estoy muy
Ok,
segura.
muy bien. Y el apartamento es el número 19. El
Sí.
código postal es 33197.
No estoy segura del código postal.
Okay, this is what I could get from her, Your Honor. She's not sure of the avenue nor the zip code. It's 11100 Southwest 196th Avenue, apartment 19, and she believes that the zip code is 33197. She indicated that she just moved in. That's why she's not as familiar with the address.
Hold on a second. Do you know what this will be? Yeah, okay. All right. And how long have you lived there, ma'am?
Señora, ¿y cuánto tiempo tiene usted de vivir en ese apartamento?
Ahí lo que llevo son 2 meses nada más.
I've been there for just 2 months, that's it.
Where did you live before?
¿Dónde vivía usted anteriormente?
En la 14211 Southwest 88 Street 33186.
¿Y eso era apartamento o casa?
Es apartamento
Apartamento número.
303.
Your Honor, previously she lived on 14211 Southwest 88th Street, apartment 303, and the zip there is 33186. Or was 186. She no longer lives there.
How long did you live there?
¿Y cuánto tiempo duró usted en ese apartamento?
1 año y 2 meses.
A year and 2 months.
All right. Based on what she's telling the court, the fact she has no priors, I'm going to go ahead and review the arrest affidavit and make you find a probable cause. I'm going to refer her to pretrial services with an alternate bond. Count 1, 2,500, count 2, 2,500. Okay?
Debido a que su señoría ha podido confirmar los dos últimos sitios, parece que usted tiene ya más de 1 año viviendo aquí y usted no tiene antecedentes penales, su señoría ha determinado que el informe de arresto tiene motivo fundado y le está concediendo el servicio de intervención previa a juicio con fianzas alternas de $2,500 por cada acusación. Muy bien. Buena suerte, señora.
Andy Garcia.
Your Honor, the gentleman that you requested, I'm already getting him ready. So as soon as he's here, I'll let you know, okay?
Thank you very much. All right.
All right, let's switch it up a little bit. Let's go to Texas, and we'll see what's going on with Judge Stevens this morning.
Well, when y'all stand close to each other, yes. He does. Hey, Bruce, a couple of things here that jumps out at me. As you know, this thing's 4 years old.
Right.
It's too old. We got to move forward.
Right.
So how are we going to do that?
Yeah, I'd like to get that discovery so I can defend this case.
Well,
what's
okay, so let me respond to that, Judge. If his contention is that he's going to utilize this discovery to defend this case, that is absolutely ludicrous. That it's the amount of loss is not even an issue in the indictment. There is no complainant listed in the indictment. That'll be his next thing he points out, which is that the complainant really recently passed away. So if this discovery is designed to determine the restitution and he wants to resolve this case, then yes, I'm for it. But the amount of loss simply isn't an issue. I've always agreed to a limited version of producing this discovery under the assumption that he was trying to get it to make arguments about what the restitution should be.
Well, but it's a lot more than that, relative.
It absolutely is not, actually.
To the fraud is an essential element.
Okay, well, how does that amount of loss have anything to do with intent to defraud? One shred of evidence.
Case.
Okay, well.
But you know, it should be very relevant to the amount of restitution, if it is.
Which is not something the jury even determines.
All right, y'all through? What is it everybody wants?
Okay, Judge Mark Lambert, I'm here for Purdue Good Credit Union. I guess I'm the point of contention here. At this point, we've received a subpoena. We've objected to the subpoena for the records that Mr. Cobb are referencing. Under Section 59 of the Finance Code, the only possible way I can produce these records for Mr. Toon, whose records are being sought, is if he is served with notice and has the opportunity to object and signs a waiver. Otherwise, the financial institution can be held responsible for releasing privileged and private information and operating information. Obviously, that didn't happen. He's now passed away. The only other opportunity for Mr. Cobb and Mr. Eckert to get these records, if the court so desires and grants, is if the court will sign an order for us to provide the records to the judge for an in-camera inspection to determine the scope of the records that would be either admissible or discoverable and any redactions therefore. I don't think I can technically redact until the court says these are the records we have to produce. So we have a subpoena sitting on us that is due. I have objections that I filed with the court. I just don't know the scope of what the court will require me to produce to the party.
What do y'all say about what the gentleman just said?
Well, Mr. Kuhn was supposed to have gone and done a waiver, which we had agreed that he would sign, but he never got around to signing it because he passed away in the process. I've been a lot better than for.
We know he's passed away. What are we gonna do about it? We can't change that. We move forward and there's, we're moving forward one way or the other. The passing away of an important person involved in a lawsuit doesn't scuttle what the grand jury has indicted. So we get forward.
Judge, I think you need to order the bank to give you the records and camera.
That seems to me the proper way that this court has control over the situation, and all the parties are placing it into the hands of the court in these pretrial matters, which I think is where it needs to be. And when there's a disagreement of the way things should be. What I want from the bank is a proposed order, please, that
probably has
fits with what you deem under the law is the way to proceed, that also is in the best interest of your client's liability exposure. And I can appreciate, my dad was about her, so I will appreciate the caution. But this is 4 years old. It's way too old.
We had worked on an order. And I think
I have a motion to compel discovery here back in from January, and then an order granting a protective order here. Was this presented by?
I think it was a mutual document drafted by Mr. Cobb and I initially to protect us until he could get the waiver signed by Mr. Kuhn. And I think at the end of that order, if I remember correctly, is the section 59. And it sets forth the documents that he wanted and that we would be protected.
Have you seen this?
I believe I have.
Any objections for me signing this?
What's the scope of what's to be produced?
It's that same thing that I mentioned.
Well, Bruce,
when you do it, it bothers him.
Yeah, because it's way broader than what we talk about.
He's always grabbing for his wallet when you're near him, Bruce, for some reason.
And just so we're on the same page, Your Honor, we're talking about a lot of records. They haven't been sifted through by the bank because we didn't know the scope. So I can narrow it down to whatever scope that the court orders or the parties agree on. I just need some guidance.
Yes, this number 2 here is the scope of what I've agreed to obtain for them.
Got both Mr. Coker and Mr. Cobb's signature on this.
Sure.
That will be made a part of the record, and we have a defendant's motion to compel discovery and request for hearing this.
What
else? Go ahead. It's moot.
We already had.
You withdraw this then?
Yes.
Okay, then. So what's next on this 4.5-year-old case to move it forward? What do we?
They're going to submit an order.
Yeah.
Okay.
Yeah.
All right.
They've yet to tell me.
May not work depending upon what's going to be necessary for preparation, but it'll stay there on that docket, and it'll be at least a goal for us to reach.
Right.
To try to reach. What else do we need to do today that you need from me?
I think that's about it, Your Honor.
Okay. From state, how many witnesses are you guessing you're thinking about? And maybe
5 to 10.
Okay.
5 to 10.
All right. Anything else? No, thank you very much. Then we'll see you back in August, I guess. Try to do what you can to be ready.
Right. And the documents will be submitted to the court, you know, so.
Absolutely. We'll submit an order to Mr. Records, Mr. Cobb, and have that to him this afternoon. I can have the records to him next, or to you, Judge, next.
While we got this,
Yes.
so I'm not in the dark.
Uh-huh.
That's because I don't know anything about the facts of this case. I can look at the probable cause and that's all I can see. What is it that each of the parties are asking me to be wary of and to pay attention to?
Well, for one thing, I think they're going to have his co-defendant testify, and I'm going to have to
No, I'm
probably.
talking about the records.
Or the records?
Yeah, I'm not talking about that. I'm talking about the records.
Outside of the proper didactic.
I'm going to get a bunch of records here.
Yeah.
And I want to be able to sift through what's relevant for me to look at and what I don't need to spend the time looking at.
Well,
what's the defense?
Part of the thing that we are contending is that this was a normal construction. Somehow this was a construction case that went awry. And the complaining witnesses stopped the work, which is rare. The normal case would be like a roofer. When you give $20,000 to a roofer and he starts to work on it and he doesn't complete the job and runs off. This isn't the case at all. These people worked on the job until fired. They were fired by the Coons, and for some reason, the Coons also sold it, did a sub sale, and also had debt forgiven by the do-good. And what this does is it pretty much cleans it up. There was no intent to defraud ever.
I'm not asking for your final argument. I'm just asking for what is it that I need to be paying attention to. Your view in these gigantic.
I need to find out if the Coons ever put some money up front that was never.
In the records.
In the records.
What is it in the records I need to be looking at?
Well, that's just partly it. But, you know, the thing about it is how the do-good controlled the draws and gave the money to Mr. Coon. And Mr. Coon was the one that gave it to the co-defendant. And then the co-defendant actually had him, you know, supervise the work on the job.
Okay.
That's what it is. This should have been a civil case. And Your Honor, there's one other thing.
The grand jury thought otherwise. That's the way it is.
I don't think the grand jury ever saw that there was a $1 million.
You were in the grand jury room? That would have been an illegal act.
No,
you don't know, Bruce. Can't talk for them.
Even
and
so,
you trust it that they're going to abide by their oath. And until you tell me otherwise, don't badmouth the grand jury.
No, Your Honor, but this is a
don't
complicated
criticize
case.
the way that this is done unless you have something to say about that's articulated. They came up with an indictment, and you know, grand juries, from my experience, they don't dream it up, and it's probable cause. This is beyond a reasonable doubt. That's the big difference. But don't be arguing, you know, a grand jury indictment. It's there, so we're dealing with it, and we got to move forward with it. That's a waste of time, unless you could say that the grand jury did something wrong, which I've never had that presented to me in 44 years. Okay, from state.
I would urge you to go through the redactions with a heavy hand because it is virtually pointless. What he's describing is nothing that is relevant to this indictment of whether or not this man misapplied trust funds. This is, I mean, the only reason I've even agreed to this is because it's taken him a year and a half to get this.
Okay, well, we're fast tracking. You got my attention, which is going to move this case forward. From the third part.
How would you like them? I can do them in paper form, digital, zip drive, whatever the court prefers, and it is easiest for you to review. And representation.
Well, everybody's gonna get the copy of this.
Once you've had your, just like with CPS records, Judge, you have to decide what is redacted first. And I will say for the record, that typically when CPS like this, so CPS often produces records in camera like this for this court to review. They submit proposed redactions.
Okay.
With their records. I understand that may take you longer. However, that often is what the court looks at and relies on.
Okay.
Just so you know.
Well, I guess hard copy is easy to. Nowadays, I really don't know. I'm just used to hard copies.
You're talking about thousands of pages, though.
Judge, how about I do both? Hard copy and a zip drive. Would that be easier?
Yeah, because I can pass on those to the parties. It's easier without getting a pickup truck. Okay, let's see what we can do quickly, and then we've got an August trial date.
Thank you, Judge.
Thank you.
Thanks, Judge.
We'll be here.
You've got Roberto Mears.
Yes. Who's the next one? Well, yeah, but I need to see, yeah, I need to.
All right, let's switch it up. Lawrence County, Ohio, the Dungeon Court. We need to compose some kind of a creepy dirge to play to introduce this court. So if you're newer to the channel, if you haven't been here before, if you're not familiar with Dungeon Court, we love this court. So much that we actually even made a brochure for it for channel members. It's clearly held in a basement. It's creepy. It's a combination of Cold War and torture chamber. The production values are horrible. The judge is cranky, and all of those reasons are why we love it. So let's spend a few minutes there. Enjoy.
Be here. I'm sure they notified me. I just didn't receive it somehow. It was kind of a crazy time in my life, and I had no idea.
You would have been told on you were here on July the 15th,
right,
of 2016, and another hearing was set for August 19th. It was to give you a chance to get your license back.
Yeah, and
you have your license with you?
Yes, I did. I got them recently. I didn't even know I had a warrant. I just got them this last few months, and I've been clean for the last year.
Okay.
And I didn't know I had this warrant. I about actually just got my license. Got all my fines still taken care of in West Virginia and Ohio. And I completed treatment a few years back. I just didn't know it was lingering out there. And I paid all my fines off everywhere else. I didn't know I had this warrant out for me.
This license was just
I just got it.
April the 8th of 25.
Yeah.
Okay, well, I encourage your getting clean. That's a good thing.
Yes, sir.
So what I'll do, this was a failure to reinstate license. If you'll pay the court costs, I'll dismiss it. Can you pay the court costs?
Yes, sir.
$25.
That's fine.
Pay that today?
Yes, sir.
Okay, see the clerk will be dismissed upon you paying court costs. So what I'm going to do, though, because I've learned a few things over the years. I'm a slow learner, but eventually I'll learn. People tell me, like, I'm not saying you're going to do this, but people say, yeah, Judge, I'm going to go pay the cost.
Yes, sir.
Then they walk straight out the door and never pay the cost.
I understand.
So I'm going to put it on the docket, and then if you haven't paid it,
absolutely, I'm going
you
right
have
now.
warrant issues. So
Yes, sir.
I'll set it for pre-trial on July the 18th.
Okay.
If you paid it by then, it'll be dismissed.
Okay, thank you.
If you got it today, I suggest.
Yes, I'm going right now.
Before you leave.
Absolutely, right now.
Any questions about what you got to do?
No, sir.
Okay. Congratulations on getting cleaner.
Yes, thank you.
State of Ohio versus Cameron Lambert, case number CRB 1978.
Okay, this was a theft offense, and your Cameron Lambert.
Yes, sir.
It's alleged that you failed to appear for a review hearing on it. October the 16th, 2019, and got a warrant for failure to appear. And it looks like you got arrested on the warrant. Is that right? You admit you failed to appear?
Yes.
You have an explanation?
I was actually living in Beckley, West Virginia, about 3 or 4 hours away from here at the time that happened. I moved from that address and just simply didn't know. I paid all my fines. I completed all my community service. I thought it was over with. I wasn't aware that there would be a review process. Otherwise, I'd have definitely come.
Well, I'm showing that you did pay your fine, but I'm not showing you did your community service. Where did you do your community service?
I mowed grass with Tim on several occasions. On the days that I made my payments, some of those days are days that I did my community service as well.
It's not entered. I had no credit for community service for you. I'm showing you still owe 5 days of community service.
Okay.
Where are you living now?
I live in Chesapeake.
So you came back?
I did.
Are you from here originally?
No, sir.
From Beckley?
Correct.
Well, you could have avoided all this if you'd stayed in Beckley, but you didn't. So now you got to take care of it. So you owe a warrant fee and 5 days of community service. So what I'm going to do, and now you have a bond up, so it won't go 6 years before 5.5 years. Because if you don't show up now, the bail bondsman does not see, what did he post for you? $1,500. He
Yes.
does not like paying $1,500 to the court.
Yeah, and he doesn't have far to go to find me now, so.
And he almost never pays $1,500 to court because he goes and snatches people up when they don't show up for their hearings.
Well, I will definitely be here.
So you have to come.
So I am going to have to recomplete the community service.
Or if you got some documentation or something
I
that
don't
shows
have
you
any
did the community
paperwork.
service, I'll take a look at it, but I got nothing in the file showing you did it.
No,
Mr. Newman's still around. I mean, he used to be the community service director, so.
Well, I
Yeah,
also know
say
him from
you did.
bingo, so he may remember, he may remember me.
Try
There's
that.
some chance. I will ask, however.
Remember, if you had another case, it could be that it was the one that a
Yeah,
different
did
case as well. but
Did you have another case?
research that.
All right, July 14th is going to be your next review hearing.
July 14th.
That's a Monday, July 14th at 9 o'clock. Oh, it's not a review, sorry. It's going to be a sentencing now because you have a bond up. So it'll be at 10 o'clock. 10 o'clock on July 14th.
July 14th, 10 a.m. I do have a question. How much was that fee that you said that I would have to?
$50.
$50.
Or
Was that
issuing
a
warrant.
remainder of the? Of
That's
my,
all you got left on your cost is $50.
Okay, sorry, I thought it was paid off.
Well, it was, but then you didn't show up for your review hearing, and there's a $50 fee for issuing a warrant.
Oh.
The clerks out here have to type up a warrant, and they have to send it to the sheriff, and the sheriff has to send it all police. I mean, it's worth more than $50 actually to do it, but we charge a fee for doing it, and that doesn't even probably touch the cost that actually costs the taxpayers to pay all those people to issue a warrant. Then when you show up, they gotta go to the reverse process and call it back in. It's a pain in the end.
I understand now. I just didn't know if I had occurred it that way or if it was a remainder, because I thought I had paid off for
You
the
paid
original
the
charge.
face amount, but when you didn't show up, you got a $50 additional cost for getting a warrant issued.
Is there a specific due date for that?
Whenever you, yeah.
Just, okay.
Just pay it. I wish I could set a date, but if I did that, I'd have to rope off Sims Township, just put a fence around it, and then run people out there because so many people wouldn't pay. Because the jail almost doesn't hold, well, the jail doesn't hold the people we have now. We gotta send them to Gallagher County, Scioto County, Morrow County. But we wouldn't even try that. We'll just rope off a township and run them out there where there's not hardly any people.
Herd them in.
Yeah. That's a pretty good idea, though, isn't it? Put them in tents out in Sims Township. Just get it done. Take care of it.
Yes, sir.
Come back on July 14th.
Yes, sir.
Or get it done before then you don't have to come back.
Oh, okay. All right. Thank you.
You're welcome.
State of Ohio versus Neala Barnes, case number CRB 25319.
Is it, how do you pronounce your first name?
Nyla.
Nyla.
Yes, sir.
Okay. Ms. Barnes, you have a charge against you alleged on May the 18th in Fayette Township. You caused or created a substantial risk of harm to property of another person, being a motor vehicle belonging to Stanley Craven, and that you did that without his consent. So that's criminal damaging as a charge against you. It's a second-degree misdemeanor. Carries a maximum penalty of 90 days in jail, $750 fine. Do you understand the charge?
Yes, sir.
Do you understand your rights?
Yes.
How do you plead?
Lawyer appointed.
Okay, not guilty. Do you have a job?
No, sir.
You have no income?
No.
I'll appoint Mr. Stratton to represent you. Not guilty plea is entered. Any objection to no R bond?
No, Your Honor.
She can sign a signature bond of $1,000.
Should need to be fingerprinted, Your Honor.
I'd say so, yeah, doesn't look like it's been done, so I'll make that a condition of bond. You have to go get fingerprinted. You have to take the form that you're signing as bond, it's gonna make you a copy, you take that to the jail, you get fingerprinted. And then I'm looking in July.
Let's see here.
Every day, any day in July except the 11th. Probably need to start staying away from the 18th too.
Okay. And I'm not good the 7th, 21st, and 28th. So
Okay, how about the 14th?
14th will work, yes.
July 14th. The next hearing will be a pretrial, 10 o'clock.
Okay, thank you, Your Honor.
You are.
Let's step inside and
Yes,
talk.
thank you, sir.
You are.
State of Ohio versus Zoe E. Steele, case number CRB 2531.
Ma'am, are you Zoe Steele?
Yes.
Have you received a copy of the charge?
Yes.
The charge is aggravated menacing, and it alleges that in Union Township, May 22nd of this year, you knowingly caused Cameron Berry to believe you were going to cause serious physical harm to the person or property of Cameron Berry. That's a first-degree misdemeanor aggravated menacing charge, maximum penalty 6 months in jail, $1,000 fine. You understand the charge?
Yes, sir.
You understand the rights you have?
Yes, sir.
How do you plead?
Not guilty.
You want a lawyer appointed?
Yes, please.
Are you working?
Yes.
What do you do?
I'm a barista at Bigby Coffee in Proctorville, Ohio.
At what church? Did you say a church?
No, coffee shop.
Oh, okay. I thought you said priest. You said
Barista.
barista. I thought you said a priest. Okay. I have to determine your gross annual income. What do you make in a week, a month, or can you tell me your gross annual income? What do you think you make?
I've only been there for about a month. It's $11 an hour, and I'm working part-time right now.
Okay, well, you're going to be eligible for court-appointed lawyer then. Okay, I'm going to appoint Mr. Steyer to represent you. Enter a not guilty plea. Is there a protection order requested here?
Yes, Your Honor.
Is there any problem with you staying away from Cameron Berry?
No.
You don't live with this person? Okay, you're not to go around, contact, or post things about Cameron Berry while the case is pending. And you're going to sign a piece of paper saying as much. So that's called a protection order, and you'll get a copy of it, and Mr. Steyer can go over it with you. I'll let her sign a $2,000 signature bond.
When are you looking at coming back for cases, Your Honor?
In July, the dates that are pretty filled up already are the 11th, 18th, and the 7th isn't that good. 7th, 11th, and 18th are pretty full. So she will need fingerprint too, so we'll make that a part of the bond.
21st work, Your Honor?
Yes. July 21st. The next hearing pre-trial at 10 o'clock.
July 21.
All these fingerprinting requirements, we have to move the courthouse back to Burlington, where it started. And these people were on so long, I put it there to begin with.
Sign here and here. And then you don't want to leave until you've gotten a copy of this from her. I'll come talk to you, but it may be a few more minutes before she gets back to you. Thank you.
Do I do this with you as well, or do I take this with me?
You keep that. And I'll come out and talk to you in just a couple minutes. Wait for me in the lobby. Thank you.
State of Ohio versus Brenda Ritchie, case number TRC 23507, A, B, C, and D.
You're Brenda Renee Ritchie?
Yes, sir.
Ms. Ritchie, this is an older case. It's alleged on May 7th, 2023 at 6:13 p.m. in Fayette Township. You were operating a motor vehicle while you were under the influence of either alcohol, drugs, or a combination of those things. So last it would be your first conviction. You got convicted. On a first offense, the maximum penalty, 6 months in jail, $1,075 fine, 3-year license suspension. The minimum penalty is 3 days of treatment, $375 fine, 6-month license suspension. You understand that charge?
Yeah.
Also charged with not having a license. That's unclassified misdemeanor. Maximum penalty, 500 hours of community service, $1,000 fine, no jail time though. Not wearing a safety belt, that's a mandatory $30 fine. And failure to control your vehicle, that's a minor misdemeanor, maximum penalty, $150 fine. Do you understand these charges?
Yes, sir.
Do you understand the rights you have?
Yes, sir.
How do you plead to these charges?
I'd like to plead not guilty so I can get a lawyer.
Okay. I mean, are not guilty plea for you? Are you working?
Yes, sir.
What do you do?
I clean King's Daughters Hospital.
Are you paid by the hour?
Yes, sir.
How much per hour?
13.
How many hours a week do you work?
30.
Okay. Well, you're going to be eligible then if you're working part-time. All right, Mr. Warford, I'll appoint you.
Good. How about you?
She has a bond out now. She's posted a bond. We'll set this for a pretrial, and the dates that are available, actually in July, I'll give you the dates that are available. The 7th, the 11th, 14th, 18th, so the 3rd, and then the 21st and after.
Judge, I'm not available the 3rd. That's the only day I'm unavailable in July.
21st then?
21st works.
July 21st will be the next hearing. And that'll be a pretrial at 10 o'clock.
Federal High versus Robert Skaggs, that's number CRB 24212.
All right, this was set for a sentencing hearing on June 23rd, so that was Monday. And so as you weren't here, and I'm assuming you got a call from Mr. Sowers.
I spoke with him, yes. I didn't show up on Monday, kind of forgot really. My wife, her mother was in the hospital having heart surgery on Monday. So I was honestly had forgotten to come up Monday but due to everything else. And I spoke with him Monday afternoon, I think it was. He told me to come up today. And
Okay. I'll withdraw the warrant since you've shown up today. And you still owe some community service and just $20 on your time. Okay. It went up. There was a additional court cost, so. All right, do you have, what about your community service? When are you gonna get that done?
I'm going to try to get it done as soon as possible. I was supposed to, went over a couple of weeks ago with the lady at Salvation Army and done it, but she was out, I guess she was sick or something, so I didn't actually get to.
Salvation Army where?
In Portsmouth.
I believe I'll approve that. Okay. All right, get it done. Now you're gonna be on the sentencing docket because you've got a bond up, which means it won't take years to get you back in here because you know Mr. Sowers is very diligent about getting people in. Okay, so I'm gonna set you the next hearing. July 28th. And that'll be a sentencing hearing. 10 o'clock. Get this finished and you quit coming to these hearings.
Will do.
Okay.
Thank you. Have a good day.
You too.
State of Ohio versus Jamie B. Bias, case number CRB 24603, CRA 2046A and B, CRB 2049.
Okay, this was set for review on June 20th, a week ago. Surprise, you were not here.
Yeah, I was not held through Zoom. I was having issues through Zoom. I was able to get through a couple times. I think I
Okay, now
yeah, cutting in and out. Yeah.
Wasn't working.
Right. Yeah.
Okay, you've done your community service, you're working on your funds now.
Yes, sir.
You don't have that much left.
How much do I have left again? I've got
I'm
that.
showing $200 total.
Okay.
For 2 cases.
Okay. That's everything total, correct?
Everything.
Okay.
You have a payment today?
Honestly, it would probably be, I can make it better. I could make a small payment today, but if I could have a couple days, I could make a more substantial payment.
Let's do a small payment.
Okay.
Just to show some good faith.
$10 it is then?
Okay.
Also, may I say something? I'm in Lexington only for a couple more months. If I could continue to do the Zoom until I move back here, that would.
That's fine, as long as you're making progress on your case.
Awesome.
I mean, you're only gonna have $190 left.
Yeah, I'm ready to get this over with.
So I'm gonna set it, I mean, apparently, we had other people that were able to appear by teleconference, so it must have been something on your end.
It was my service, yes.
Okay.
I've done it for months. It's been fine. Just last week was the issue, so I appreciate you letting me finish through Zoom though. That helps.
Okay, I'll give you till August the 8th, so you get it done by then, you don't have to be here either way.
August the 8th, 9 o'clock.
9 9 o'clock.
Okay, thanks, sir.
You're welcome.
Okay, we could stay on Dungeon Court for days, but that's not necessarily what we do here at TCF. We try to move around a little bit. We'll probably come back to them, though. In the meantime, let's go back to Miami-Dade and Judge Maria Espinoza-Dennis.
Alleged victim is Martiel Swanko. I'm going to set standard bond on this with a stay away order. Count 1, 7,500.
Judge, would you be willing to consider house arrest on this particular case? Mr. Newton-John is the primary caretaker of his wife who's suffering from brain atrophy. He does need to be home to take care of her.
Also take her to appointments. She
What
has.
documentation do you have that would substantiate this?
What, I'm sorry?
Documentation.
Yeah, what documentation? I mean, this is,
I mean, you can call her and she can give you the doctor's name. When they arrested me, I didn't walk with documentation, Your Honor.
Okay, he may not qualify, as I said, for the public defender's office, not sure for purposes of this arraignment. I'm not inclined to do any pretrial services. I was going to set standard bond at 7,500, count 1, count 2, 2,500 with a stay away order. That's $1,000.
Oh, Judge, I was requesting house arrest.
Not inclined to do that, ma'am. All right, it's a crime, looks like a crime of sophistication. All right, next. This is Daniel Rodriguez. Daniel Rodriguez. Is this Mr. Rodriguez? Do you speak English, sir?
Your Honor, he's being held on a probation violation, no bond.
Yes, I have him out on probation in case number F1610496. So he will have a probation hold on that case until he goes in front of that judge, Division 14.
Your Honor, did he ever answer? Señor Rodriguez, ¿habla usted inglés?
He speaks English.
Oh, okay.
In this case, he is charged with possession of a controlled substance, MDMA, which is a third-degree felony, allegedly taking place on June 26th of this year in the area of 11503 Quill Roost Drive in Miami. Okay, so this is a search. Bond 2,500, but he's got the probation hold. Okay, PC found. Next case, Lloyd Farson.
You may qualify for pretrial.
Good morning, sir. All right, it's claimed that you committed the offense of the possession of a controlled substance, third-degree felony, and possession with intent to use drug paraphernalia, first-degree misdemeanor on June 26 in the area of 17317 Homestead Avenue. Okay, he just has a prior cannabis, which was withheld back in 2011. Where do you live, sir?
17255 Southwest Avenue, apartment B 158.
Southwest, what avenue? This is wrong.
Apartment B 158.
I have a 10950 Southwest and 107.
Yeah, that too. That too.
That's
Awesome.
two addresses?
Yes, ma'am. Yes, ma'am.
So which is the real one? The 105.
109.
The 10950 Southwest 177th Street?
Correct.
And who do you have a name of either a family or friend that can confirm your address that you can
Yeah,
give?
my dad, Leonard Farquharson.
Okay, and what's the telephone number for him? confirmed to pretrial services, alternate bond. Okay. $500 count one, $500 count two. Next case is Abraham Garcia.
There's a bond out, Your Honor.
Next case is Omari Rodriguez.
Judge, he does need the services of the Spanish interpreter.
Okay, is this Mr. Rodriguez?
Yes.
Okay, all right. Okay, Mr. Rodriguez, good morning. You are here before the court because it is alleged that you have committed the following offenses, sir.
Buenos días, señor Rodríguez. Usted está aquí ante este tribunal porque se alega que usted cometió los siguientes delitos.
Judge, we can waive the reading of the
Okay.
charges.
Su abogado quiere que no se haga lectura formal de las acusaciones que hay en contra suyo.
All right. You will advise him of what they are.
Correct.
La abogado que se encuentra a su izquierda le va a informar de cuáles son dichas acusaciones.
Okay, in addition to which the state of Florida has filed
Además, la fiscalía también ha presentado el siguiente pedimento.
a motion for pretrial detention,
Para retención previo a juicio,
and they've also provided a proposed no contact order from the alleged victim whose initials are MC.
también han propuesto una orden de no contacto, una propuesta para orden de no contacto con la víctima cuyas iniciales son M de Manuel, C de Carlos.
Okay.
You know, and I apologize. When I said those two names, it sounded like I was giving the name. It was just M as in Manuel and C as in Carlos. Now I realize it sounded like the name.
You're good, you're good. Okay. All right, any arguments with regards to probable cause so I can make my findings?
Argumentos con respecto a motivos fundados para su señoría poder determinar sus hallazgos.
All right, the court has reviewed the arrest affidavit and will grant the state's motion for pretrial detention, and that's related to count 2 of the arrest
One
affidavit.
and two.
Two.
I'm sorry, Nessa. You said one
Counts
and
one
two?
and two.
Two.
Okay. Su señoría ha determinado mediante el informe de arresto que hay motivo o motivos fundados para las acusaciones y va a conceder el pedimento de la fiscalía antes de las acusaciones 1 y 2 para retención previo juicio.
And then as to count 3 and 4, the bond is going to be $5,000 on count 3 and $1,000 on count 4. No bond.
Y con respecto a las acusaciones 3 y 4, $5,000 de fianza con la acusación número 3, $1,000 de fianza con respecto a la acusación número 4 y no tiene fianza en las acusaciones 1 y 2.
Honor, what was 5?
Oh, is there another? Oh my gosh, yes, you're absolutely right.
Una de las carceleras preguntó por la acusación número 5 que aparentemente no había visto su señoría.
That is $1,000 on count 5.
Acusación número 5 va a ser $1,000 de fianza.
Thank you for pointing that out. With regards to the stay away order, if he's able to post a bond or modify any of these conditions, one of the conditions of any release will be that he cannot have any contact, direct or indirect, with the alleged victim in the case whose initials are MC.
Y si acaso sí puede usted adquirir fianza, va a haber una orden de alejamiento con la supuesta víctima, con las iniciales MC, donde usted no podrá tener contacto ni directo ni indirecto con supuesta víctima.
At least 500 feet away from the alleged victim.
Tiene usted que estar a todo momento dado mínimo a 500 pies de distancia a la supuesta víctima.
Not use or possess any drugs, do not have any weapons, and not commit any criminal activity.
Usted no puede poseer narcóticos ilícitos, no puede poseer armas, ni puede participar, no estar en ningún tipo de conducta delictiva.
Good luck to you, sir.
Buena suerte, caballero.
Top of page 8, Tony DeFell.
All right, let's switch it up. Let's go to Detroit, and we will go to Magistrate Court there. Haven't been there in a couple of weeks, so let's check that out.
And so he is not going today.
So
And
what
all of you will come down here.
Just hold on one
Okay,
second.
hold on a moment. Hold on one moment. Okay, go ahead, Mr.
I'm gonna talk to Miss Jackson because it's 100%. And I know there's some cases that they have some files for, but man, he can't sit in jail for 3 days on some misdemeanors because of a file. So I'm gonna talk to Miss Jackson and try to see what we can do. For Mr.
All right, you let me know. You see what you can
Okay.
do and you let me know.
Okay.
So hold tight
I
for a moment,
appreciate it.
family. Okay, all right. Okay. So Miss Scheiber, the one KP is Mr. Hightower. Marcus Hightower, and do we call Judge McConicle?
Yes, Your Honor, he should be signing on still.
So Judge McConicle should be signing on soon on that one. And ma'am, at DDC, your name, please.
Hi,
Miss Tatum, okay, good morning.
They say hi.
All right. Yes, okay, so Mr. Ali, we're just waiting, hold on. All right, oh, that's right, we keep using Hightower, which is the alias on it, okay. So we have to wait because the chief judge is going to handle that matter, okay? And we also
Your Honor,
need,
we're ready on the walk-in whenever the court is,
Please go ahead and go with the walk-in while we're waiting for Judge McConicle.
Mr. Barnett. I'm sorry, Miss Barnett.
Miss Barnett in the courtroom. Step forward, ma'am. And Mr. Hightower / Ali, we'll get to you just as soon as we can, okay? I know the deputy said you had to be moved, but we're gonna handle this matter and wait for the chief judge to zoom in. Okay, ma'am, good morning.
Good morning.
Would you state your name for the record, please?
Barnett.
Barnett, okay. All right, Miss Barnett has some tickets, and so I'm going to address the tickets first, Miss Child. All right, Miss Barnett, because you failed to appear on some tickets, there were bench warrants that were issued. So I'm gonna set those bench warrants aside, okay? You have the right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney, and if you cannot afford an attorney, one would be appointed for you. Court is calling ticket number SP 11998-401. All right. There you're charged with driving with license suspended and no insurance. Ticket number SP 1509932. You're charged with no insurance. Ticket number SP 1576506. Failure to display a valid driver's license. Ticket number SP 1633506. You're charged with driving with license suspended and no insurance. So, Ms. Barnett, for those particular charges, you could face up to 93 days in jail and/or receive a fine in the amount of $500. I'm going to enter a not guilty plea on your behalf, set a personal bond in these matters, and you have a pretrial that's scheduled for July the 11th at 9:00 a.m. That will be by Zoom before Judge Yancey. Okay, so you'll get some paperwork before you leave, but just keep it in your mind. All right, then I need you to restate your name for the record. I'm going to call your main case.
Barnett.
Okay, court is calling case number 2504 533-601. The people of the state of Michigan versus Adrian Chatan Barnett. Okay, can I have your appearance, Ms. Shai?
Yes, do we have prosecutors, Your Honor?
No, not today.
Oh.
No, today,
okay,
they sent a message to Mr. Reagan. I saw him on the
Oh,
list that they,
okay.
not here today.
I'm sorry, it was, okay, thank you. My colleague just let me know. Okay. Good morning, Your Honor. Jessica Shipe, number 81798, on behalf of Ms. Barnett, who is formal reading, understands her constitutional rights and stands mute.
All right, then the court will enter a not guilty plea on behalf of Ms. Barnett. She is operating while intoxicated from 2023. Your position on bond.
Your Honor, she walked in, turned herself in, not on probation or parole, no priors, lifelong resident. This allegedly is from 2023, not entered until 2025. I'm not aware of any incidents before, after, or during. I don't believe she's a flight risk or alcohol tether is necessary. So respectfully asking the court to consider personal bond and no drinking, of course.
Okay, so Ms. Barnett, thank you for walking in, attempting to resolve this matter. It is, a bit old, so the court is going to set a personal bond for you in the amount of $5,000. That means you don't have to post any money. However, while you're on bond, ma'am, you are not to use any alcohol, okay? And certain down the road, you probably have some other conditions imposed by the judge where your pretrial is going to be held. Also, you're not to drive without a valid driver's license. Okay, you do have a pretrial that's scheduled for July the 8th. Now, remember, you have another one. This is a pretrial before Judge Jones. It will be by Zoom. Okay, so July 8th at 8:30. All right, and that concludes this matter. All right. So let's see.
Can I
We
have
have
the
a
bond
Chief
amount
Judge
one more
here.
time? Your Honor, I'm sorry.
5,000.
Thank you.
5,000. You're welcome. Good morning, Your Honor.
Good morning.
How are you?
Well, how are you today?
Doing good, thank you. So we have Mr. Hightower. He's also known as Mr. Ali. Okay.
Can you
Right, Mr.
call
Ali.
the case? Can you call each offense and let me know what the bond is? Thank you.
Sure will, Your Honor. And just for the record, the prosecutors are not appearing today, so Ms. Shive will be representing Mr. Ali. Okay. Okay, so Mr. Ali, can you have someone to unmute you? Okay, thank you, Deputy. All right, the court is, okay, state your name for the record, please, first, sir.
My name is Tyshawn Antonio Ali.
Okay, and are you also known as Marcus Hightower?
No, no.
No?
No.
Judge, I'm sorry. That's Mr.
Okay.
They called this young man Marcus Hightower. Philip Reagan on behalf of Mr. Ali. I'm sorry, Mr. T. How do you pronounce Tyshawn? How do you pronounce your first name? Is it
Tiesha.
Ali. So, Judge, Mr. Ali's 19 years of age. His date of birth is, where's Mr. Ali? Regardless, Judge, this case is from 2021.
So we have to call the case first. I mean,
I'm sorry, Judge. They just told me he was on. They told me just,
no, we were. I guess there was preliminary information being obtained.
I apologize.
Hold on.
Okay, court is calling case number 21062265702. The people of the state of Michigan versus Marcus Hightower. Your appearance, please.
Judge and Philip Reagan, good morning to everyone. Philip Reagan on behalf of Mr. Tyshawn Ali, but he's also known in this complaint as Marcus Hightower for purposes of this complaint.
Okay, Your Honor, and the complaint indicates that on 12/16/2021, in count 1, Mr. Hightower is charged with receiving and concealing stolen property, $20,000 or more. It's a motor vehicle. In count 2, is charged with fleeing and eluding police officer 3rd degree. And count 3, charged with police officer assaulting, resisting, and obstructing. And on June the 30th, 2022, he failed to appear for a preliminary examination that was scheduled before Judge Archer, and bond was set at $5,000 cash or surety.
Mr. Reagan?
Judge, again, I'm sorry. Philip Reagan on behalf of Mr. Ty Sean Ali, also known as Marcus Hightower, for purposes of this hearing, Your Honor. My client, Judge, is in the Wayne County Jail now. He's 19. Date of birth is 4/21/06. So, in 2021, he'd be like 15 years old. Now, he tells me that he has no idea about this case. This is not him. I don't know how, they have it tied in, but that's where we are on this, Judge. It's a 2022 non-assaultive capias. I think they need to get the paperwork figured out over there, or, if not, Judge, I would ask that he be given a personal bond on this case, come to court, get it figured out, so they can see that it's not him. He's 15 at 2021. It's 2025 now. It's 19.
Court, I've heard the arguments of counsel. There seems to be some confusion, or this is gonna have to work itself out. Court is going to reduce the bond from 5,000 cash to 5,000 personal. Mr. Ali, make sure you get your court date. Make sure you appear at your court date so that your attorney, if you're saying this is not you, can make the arguments to have this matter dismissed against you, and that, so they can find Mr. Hightower, or whoever that may be, if that's not you. With that being said, 5,000 personal.
Thank you, Judge. And Madam, I'm sorry. Magistrate Bergen, what's the new court date? I'm sorry. I apologize.
Okay. Mr. Hightower has a probable cause conference that's scheduled for July the 8th at 8:30. That'll be before Judge Giles by Zoom. He also has the right to a preliminary examination. That's scheduled for July the 14th at 8:30. That will be in person before Judge Giles in the 36th District Court. Okay?
Mr. Ali, you got those 2 cases, okay? All right, there's 2 dates. I'm sorry, not case, but 2 dates, July 8th, July 14th. Don't write those down over there, okay?
All right, bet.
All right, good brother.
Okay, all right, sir, take care.
Good.
Okay, let me see who Mr. Upshaw's on. Might have to have.
Hey, let's switch it up. Let's go to Texas. Judge Stevens. We'll go back to him. And a special guest has just entered the studio, so perhaps we'll have her on in a little bit.
Daniel, what are we doing today? You don't know. It's a review.
Yes.
Okay. And
ultimately, Judge, if I may, just to bring you.
Are you representing him?
That's what I had to hear.
There's a.
No, I'm sorry. Come on, no. I thought it was, never mind, I'm sorry.
Thank you for your appearance, though. It was nice.
Judge, I can bring you up.
It's a fee issue.
Yes, sir.
Okay. There's a motion to revoke probation that had been filed last year. And this is about, these are done as you're nearing the end of probation. You were on probation for 10 years for aggravated assault. Well, it says 8 years. And then it was extended 2 more years. From 2014, when you were placed on probation, August 11th. So 8 years have been in 2022. Then it was it was extended to August of last year, and before that anniversary of 10 years was reached on August 11th, or it would have been, August 11th. Then July 9th, a month before that anniversary date, a motion to revoke probation was filed, which is normally done when there's a fee issue. They get a foot in the door, so the door doesn't close. It would close if nothing is done, and 10 years elapses, then you would have been terminated from probation. But in your case, it's all about restitution. It looks like. I mean, there was a lot of restitution ordered at the beginning. I don't know what the balance is, but it looks like it's a little under $50,000. So that's why we're here, is trying to collect money for the victim.
Actually, Judge, what we were here today for is USD. Well,
Go ahead.
It's an administrative thing. The question came up about why the victim hasn't been receiving restitution. The defendant complained about that. You asked the probation department to look into it. I knew, well,
victims.
Judge, the reality is that the victim was compensated through the Compensation Act, and we had to pay them back first. They've approved.
Wait, paid them back. Them is the victim compensation?
Yes.
Entity?
That's what's been happening. We needed to get the numbers on that. She's prepared to give you the details as to all that.
Somebody's paying it.
Yes.
And it can't be, if it's Victim Compensation Act people, that's the taxpayers. And I'm not interested at all in being part of paying restitution that I wasn't responsible for. So it's the responsible party ultimately absorbs the cost. Sometimes a government entity is formed to help the victim get their money as soon as possible. Then the governments, the taxpayers, the people who funded that, actually to get to the hands of the victim as soon as reasonable, then it gets repaid so that the taxpayers aren't footing the bill and paying for an indebtedness that they weren't the cause of. Then that's your responsibility at the end, Mr. Moten, that you've been trying to handle.
So we've got the breakdown for you, Judge.
All right.
Judge, if I may, the crime victim compensation paid in $9,237. Again, that's $9,237.91. And once we had the number for the CBC, all the restitution, 100% was going straight to them first to get them paid off. As of June 13th, 2025, just recently, he paid his $500 that he worked. The defendant paid his $500, and like I said, everything was going to CBC. He is currently paid off CBC in full. So now moving forward, any restitution that you order, $500 each month, is going straight back to the victim individually.
How much, what's the balance for that?
The balance on.
I think that's what we're all interested in knowing.
That is.
He needs to know when his $500 payments stop.
His balance on that's going to go to his father, the victim, is $42,731.29. And he has been making his $500 that you've requested monthly. Now the full 500 will go to his dad, the victim, moving forward.
Which is a balance of $42,731.29.
Yes, sir.
You understand that?
Yes,
Mr. Mote. Well, that's, we're talking about 83 months. I mean, it's a lot of time, but it's what it takes to fix the mess.
Yes, sir.
Okay. So
He's
we,
paying
good.
himself.
Otherwise, he's on an inactive state.
He's been that way for over 2 years.
It's just a matter of him coming in monthly and making payments. If you happen to win the lottery, don't spend a lot of money on that, because that's a losing deal. But if you happen to win the lottery, that can help pay this off.
Yes, sir.
But keep doing it in a responsible way. Okay, the victim is your father.
Yes, sir.
I don't mean to be.
You've already addressed that, Judge.
Working out?
Yes, sir.
Okay.
I am allowed to, right? Yeah, we've addressed all that through a memo that was handled 2 months ago.
If the victim wants that, that's what he wants.
We've
I'm all for a father and a son.
Yes, sir.
Repairing any problems.
That's all been monitored by the probation office through your efforts and what you asked of everybody, Judge.
Okay, good. Well, putting the family unit back together, and the other way is repairing by the loss, and that's how you fix it. Okay. Then I think we'll just review it 6 months, just to kind of keep an eye on things. Is that okay? Thank you very much, everybody, for being part of this. It looks like this is working. Appreciate it.
Okay, that's all for all the comments. Yes. Okay, just want to make sure if something changes, you need to listen.
On is it Jonathan Connor?
Yes, sir, I'm ready.
That's gonna be the next hearing.
Okay.
I'm sure we'll do that very last.
Do you have any?
I think so.
Have a plea.
All right, let's do it, please.
I have a plea.
Go ahead. Let's get that done.
Miss Middleton.
Milton, thank you.
Yeah. I double checked.
But Haney?
I guess it's, all right.
From yesterday?
Yes.
Okay.
She was the one I think had gone and had to.
We switched it and gave it to John. She should be at the bottom.
Yeah.
There's 2 files.
2 files. Come on.
She's.
Oh, she's out.
Custody. She's in custody. Bring her out right now, girl.
You made her upstairs.
She's-
After the time. Yeah, there is a plate. I apologize.
Okay, we've got 2 cases. What's going to be done?
5 years deferred probation, $500 on each.
On each?
Yes, sir.
Okay.
Yeah.
No restitution.
Yeah, no restitution, so.
Yeah.
One more spot time for that, if you will. It's what evenings. There's no delay.
Look, she tested positive yesterday. Don't we need to do a drug test? Make sure that she's negative?
Well, I mean, I don't know how long it's gonna take to get out of the system, so.
Just because it's in her system doesn't make her intoxicated.
No,
I understand.
But she's been overnight.
Are y'all insisting that we move forward together?
Good. I mean,
And there's
the reason.
Yeah, you've spoken to it.
Oh, yeah,
If there's
absolutely.
any reason to believe that the defendant is incoherent or does not understand the proceedings?
No, she understands everything.
Ms. Milton, you understand where we are and what we are doing?
Yes, sir.
Okay, and Mr. West is going to help you on this. You were charged in 2 cases, 23 CR 905. Forgery of, with a financial instrument, that is a state jail felony, and 23 CR 907, which is fraudulent use of possession of identifying information. And that is also a state jail felony. Does the defendant waive formal readings of these indictments and arraignments? Can we proceed in summary?
Yes, Your Honor, please.
In summary, each of these indictments similarly state that on or about January 31st, 2023 in Jefferson County, Texas, you committed these state jail felonies that I described for you in these cause numbers 23 CR 905 and 907. You understand from speaking with your attorney what you were charged with in each of these cases?
Yes, sir.
These are state jail felonies, which mean that you face no less than 180 days, up to 2 years in the state jail, and a fine up to $10,000 can be assessed for each case. Do you understand?
Yes, sir.
Hmm. 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 What he's doing. Agreements have been reached. Well, even to the record, we're fixing the pad.
Yes, Your Honor, the agreement is on each case, 5 years deferred probation, $500 fine, no restitution and currently.
All right. Or is it your understanding, as Mr. West has just read out loud, that the plan is you would be pleading guilty on each of these cases, not found guilty, but placed on deferred or unadjudicated probation for up to 5 years? And was there a fine? $500 fine in each case, and there would be terms and conditions of probation, which is normal and customary for this type of offense in each case. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, You have no right of appeal of your cases. Do you understand?
Yes, ma'am.
How do you plead in each of these cases, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will. And because you are indeed guilty of each of these charges in these two indictments.
Yes.
I'm going to show you in each case what's marked as State's Exhibit 1. Did you sign these documents?
Yes.
Understand them, discuss them with your attorney. Are the contents all true and correct?
Yes.
State's Exhibit 1 was tendered into evidence in each case.
No objection.
Without objection, admitted. Among other things, they state that you are mentally competent to enter your guilty plea. These are freely and voluntarily made. You know what you've been charged with. The indictments have been read to you. You've read it. You're guilty of the crimes charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights of the appearance, confrontation, cross-examination of witnesses. You are totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God.
Sir.
Is that true?
Yes, sir, it's true.
Let me tell you, this pad is.
Here, switch with me.
Oh,
Log you
it
back
is.
The battery is really low on that much. Yeah, like us, it's pull up what you need.
Yeah, it doesn't want to pull up right
Yeah.
now. It's
No, it wasn't charged. I only do one at a time, so. Leave mine. Mine to me.
Fine, 500 on each. Yeah.
It's not working. This is not working.
So look at it if it's not.
I don't.
Whenever you get out. It is. 05? Are we on 07?
I think it's 05. Trying to open.
Maybe 07.
I think I already did 07 and that closed fine.
Yeah.
Check it.
Yeah. I don't have any of them back to you because I'm not logged in.
You can see your initial unknown.
Yeah. Right. There are locks with us.
Stand by, everybody. Smoke them if you got them. What's the problem on this thing? Is it me?
Loosen up behind the wheel.
Sure, you're walking the rest of the trip. All right. In each of these cases, ma'am, I show you what's marked as State's Exhibit 1. Did you sign those documents voluntarily, understand them, discuss them with your attorney, or the contents true and correct? Yes, speak out. Yes, they're all true and
Yes,
correct. Okay. State's Exhibit 1 is tendered into evidence in each case.
No objection.
Without objection admitted. And again, these state that you are mentally competent to enter your guilty pleas. They're freely and voluntarily made. You know what you've been charged with. The indictments have been read to you. You've read them. You are guilty of the crimes charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. God bless you. You are totally satisfied with the representation provided by your lawyer. All true, so help you God.
Sure.
State's Exhibit 1 in each case made a part of the record for all purposes. Pre-sentence reports waived.
Please, John, yes.
I'm going to follow these agreements. If nothing further, I'm going to find you, ma'am, Ms. Middleton, you are pleading guilty in each of these two cases voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt in each of these cases. But I'm not going to find you guilty. So long as you follow these terms and conditions of probation, you will be placed on deferred or unadjudicated probation for 5 years to run concurrently at the same time. You must pay a fine of $500. There will be other terms and conditions of probation, which are normal and customary for this. Make sure you follow these. If you fail to follow the terms and conditions of probation, your probations could be revoked. You could then be found guilty of these felonies and sentenced up to 2 years in each case. Okay? Oh, you're going to do well, aren't you? All right. Fix this, and the probation officer will go over all of this with you here in a moment. Thank you.
Okay, so back over in Detroit, the lady in the interesting choice of tops is still on camera, still waiting to be called. I would imagine they would have moved her through quicker, but she's still sitting there. So my special guest in the studio, off camera but on mic, my daughter Megan, who has been visiting with us all week, has decided to grace us with her presence. Hi, Maggie.
Good morning, everybody. It's nice to be here this morning.
That didn't sound overly enthusing. Go, good morning, everybody.
Good morning, everybody.
There you go. That's what we're looking for. So, yeah, she has to fly back home tomorrow, Tier, but it's been a good week having her around, so that's been nice. And I've hooked her on 2 things, I think, this week. I've actually, I think, hooked her a little bit on court content.
Yeah.
She actually has been watching a lot of stuff with me as I've been editing videos and whatnot. And I've also hooked her on Michael Groff weather.
Oh, yeah. Michael Groff weather is very good.
Yeah, I told you.
It's like addictingly good.
Yeah. So I don't know what better endorsement I can get you, Michael, than my daughter. And by the way, I'm not going to call you Mike. Sorry. You're Michael. It's just the way it is. You introduce yourself in your videos that way, so that's how it goes. So she'll be hanging out with us here as we continue to watch court. I just thought I'd introduce you to my daughter. Very proud of her. Good kid. Not a kid anymore. Getting married in a few months. So it's good. All right, let's... Oh, they got her off camera now and replaced her with another female who's better dressed. Well, I've already got it pulled up. Let's just listen in there for a few minutes.
All right, so who do you have that?
This is Patrick Smith, Your Honor.
Okay.
May I ask him a question just because I'm trying to get in touch with Sergeant Coho? Could you have Sergeant Coho call me? I've been trying to call him.
Sergeant Coho is off today.
Off today. That's probably why. Okay. Okay.
A little hard to reach today.
Yeah, that should be still good. Yeah, okay. All right.
Okay, so man, we'll be with you in one moment. So we're gonna deal with Mr. Smith. And your name for the record, at DDC, ma'am? Your name, ma'am, that's sitting at DDC.
Heather Greenwich Brown.
Oh, Greenwich Brown. Okay, so we'll be with you shortly. All right. Okay, Mr. Smith has a number of tickets, and so I'm going to address those tickets first. Mr. Smith, because you state your name for the record first, please. Your name?
Yes, ma'am. Patrick Smith.
Okay, good morning.
Good morning. How you doing?
You feel too, I'm doing good. How are you?
I'm not too good because this is so crazy.
I understand. You got a lot going on here and a lot of court dates that you missed, but
oh no,
there were bench warrants
Pat. Oh.
There were bench warrants that were issued, but the court's gonna set those bench warrants aside on those tickets, okay? You do have the right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney, and if you cannot afford an attorney, one will be appointed for you. Court is calling ticket number SP 1076957. The charge of driving while license suspended. Ticket number SP 1119050. Driving while license suspended. Ticket number SP 1164049. Failure to display a valid license. Open alcohol in a motor vehicle. Ticket number SP 1207600. Open alcohol in a motor vehicle. Driving while license suspended. Ticket number SP 216665, driving with license suspended and no insurance. Ticket number SP 1257314, no insurance, driving with invalid license and no registration. And the last one, ticket number 480979, you're charged with violation of the City Controlled Substance Code. So, Mr. Smith, for those charges, you could face up to 93 days in jail and or receive a fine in the amount of $500. The court is going to enter a not guilty plea on your behalf, set a personal bond, and you have a pretrial scheduled for July the 11th at 9:00 a.m. before Judge Archer. That will be by Zoom.
Yes,
Now
ma'am.
I'm going to move on to your main case. I do need you to restate your name for the record.
Yes, ma'am. Patrick Smith.
Okay, court is calling. Case number 250561241. The people of the state of Michigan versus Patrick Devon Smith. Your appearance, please.
For the record, on behalf of Patrick Smith, Your Honor, waive the reading, stand mute. He's been advised of his rights.
Okay, the court will enter a not guilty plea on behalf of Mr. Smith. Bond recommendation, Mr. Reagan.
On record,
2021.
Judge, I'm recommending a personal bond for this. This is from 2021, and it wasn't signed until February this year. 4 years later, Judge, it's non-assaultive on his face. My client has 5 kids, lives in the Metro Detroit area, has ties. So I am asking for a personal bond, Judge. It took 4 years to sign this non-assaultive case. So that would be my request and recommendation to the honorable court.
All right, it is, this case has a little age on it, Mr. Smith, but the charges are serious. Court is going to set a $10,000 personal bond. So you don't have to post any money to get out, but you're not to have any contact with Ms. Shiver. And her first name will be on your paperwork, okay?
Yes, ma'am.
All right, hold on. You have 2 court dates. You have a probable cause conference that's scheduled for July the 8th. That'll be at 8:30 and it will be by Zoom
Yes, ma'am.
before Judge Jefferson. And then you also have the right to a preliminary examination, which is scheduled for July the 15th at 8:30. That'll be before Judge Jefferson, but that one will be in person in the 36th District Court. You understand your bond conditions on your next court date?
Yes, sir. Yes, ma'am. Your Honor, can you tell me the second date again? I apologize.
Okay, and you're gonna get some paperwork before you leave the jail, but the second date is July the 15th. That's
Yes,
the one,
ma'am.
that's your preliminary exam date, okay?
Yes, ma'am.
The first one, July 8th. And don't
Yes.
forget, then you have all those tickets as well, that's July 7th, but they'll give you some paperwork before you leave the jail, okay?
Yes, ma'am.
All
Thank you
right,
so
then
much,
take
Your
care.
Honor. And thank you so
All
much.
right, you're
Rick.
welcome.
Ashley, thank you for gifting 10 memberships. Very kind of you. Oh, nope, 20 more. Thank you for gifting 30 memberships, Ashley. Legend. But here's the thing. It's actually only 29 because YouTube randomly selected me in my personal account to receive a gift membership to my own channel, which is just hilarious. So congratulations to me, to Rebecca, to Gen X Boomer, to Ryan, to TDT Fear, to Shannon, to Amber, to Andy, to Tabitha, Savannah, Debbie, She-Wolf, Moments of Justice, AC603, Princess Chicken, love that one, DWB News, who else? Aaron, Tara, Jonathan, iCat Max, Shane the Artist, Indigenous Rage, Bad Moon Rising, Lisa Small, Nicholas Funk, Beck77, The World's End, Rose Petals, Steph Johnston, Lindsay throws in 10. You guys are amazing. Love all of you. Sean, Eridow18, Wyatt, Anything for Selenas, a.k.a. AJ, Province, this is moving too fast now, Lavendu, Carmen, Roving Cyclops Video Walks, Retired Rachel. Michael says we're going to break Dan again. Maybe. We'll see how it goes. Thanks, guys. Really does mean a lot. Let's keep the party going. Let's go to Dungeon Court. Because there's this very old dude on the defense side who's got just the right amount of arch in his back to make me wonder if he's the Walking Dead.
You think you can post that? $1,500. If you got $1,500, you can deposit with the clerk. As long as you come to court when you're ordered to, you get it all back at the end of your case. If you don't have $1,500, okay, I'm not finished. If you don't have $1,500, you can hire a bail bondsman, and they're on the hook for the $1,500, but you got to pay them a fee, and you lose the fee. It's usually 10%, so you're talking about $150.
Yeah, I'll leave it $150.
These fines and costs are paid off. It's 2 days of community service, yes. But is there somebody that can post this bond?
Yes, Your Honor. How much is it, Judge?
It's gonna be about, I mean, I'm not the bail bondsman, but usually it's 15%, $150. Okay, you got a friend here that says he's gonna post your bond for you. So, you can talk to Mr. Cooper and he will help you get connected with the bail bondsman. And then I'll give you a hearing. When will you be back? Because you're gonna be out on the river for a while, then you come back?
I'm home every day, but my work schedule is, work 7 days straight, and I'm off for 3 or 4.
Okay, well, I'm gonna set it for August the 1st. That gives you plenty of time to get 2 days of community service done. And you can do community service any day but Sunday at 7:30 here at the court.
All right.
So get it done and you don't have to come back. And it'll be set August the 1st at 10 o'clock for sentencing.
All right.
So when your friend posts the bond, then you'll get out of jail, which should probably be this afternoon sometime.
Wow.
Do you have a phone number where Mr. Morford can get in touch with you?
Yes.
You want to give it to him? He's right here in the courtroom.
Yes. 740-646-4273.
4373.
4273.
4273. Thank you, sir. Judge, may I have your file?
Yes.
State of Ohio versus Michael Davis, case number CRB 25362A and CRB 24767.
Barbara, thank you for gifting 5 memberships. Dawn, Michelle, Jesse, Brian, and Sin, you are all now members. Congratulations. And I just got an email from YouTube to let me know that I've been gifted a membership to my own channel, which is very nice. It informs me you've received the Courtroom files. That doesn't flow well. Oh, well. Gift membership purchased by another fan. For 1 month, you'll have access to all the special perks and benefits of a certifiable Law Junkie membership. Yay! Go me! I love you guys. Thanks so much. Let's get back to the dungeon.
We would waive reading the violation and enter denial at this time, and I guess figure out where we are on the universal cases.
Okay, there's a problem. What's the state want to do?
Well, Your Honor, and of course, Ms. McMillan's here. She's the alleged victim of the sexual imposition charge, which we take very seriously. Mr. Davis previously had, I believe, 160 days over his head that he could serve on the prior cases. The new charges are very serious, and so we intend to pursue those. So he's got a $5,000 cash surety bond. We'd like for that, at least that amount, to remain. And if Mr. Stryer wants to set it for trial or ask for discovery, either one, we are prepared to do whatever is necessary.
I intend to ask for discovery, Your Honor.
Okay, so come back for another pretrial?
Yeah, I think that's probably what we need to do. Is there an amount you believe you could make?
I've been in here 13 days already. I was gonna see if I could get any
Okay.
1,500 maybe.
Do you believe you could meet a $1,500?
I believe I could.
Okay, well, if he believes he could meet a $1,500 bond, I would ask for that. We recognize that he does have a lot of time over his head, and that doesn't necessarily mean he wouldn't end up going back later, but I mean, with the jail situation being what it is, if we can get him out, it might be worth our while.
Oh, I think there's a number of reasons for the court not to lower his bond at this point. I think he's a flight risk. He's actually alleged to have committed a pretty serious offense here. He's got a history of offenses. He doesn't seem to respect anybody else's rights.
Sir, I'm gonna caution you not to speak at this point.
Okay, I'll lower it to 3,000. 3,000 cash assured. Now,
There's no way to get a little bit lower than that?
Doesn't sound that way, sir.
no. And when do we want to come back for the next one?
Doesn't sound like he's gonna make that bond, so I'm gonna ask for the 7th if we could, Your Honor.
All right, next hearing will be July 7th on all matters involving Mr. Davis.
State of Ohio versus William Earls, case number CRA 25-187, CRB 24-7.
Pepto Jr. gifts 20 memberships. Thank you so much. Rob, Petty, Sunshine 64, Mari, T-Cats, Cypher, Bob, Martin, Hoffnung, Funnyface 0235, Tata 603, KB, Neurospice and Sass, Debbie, Brainwind Breeze, Tiff, you are now members. Bailey throws in 10. Oh, Star Hunter, Hi Guy, Charlie, Stephen King, Nacho Wi-Fi, Amanda, Karen, Nick, Andrew, Helen, Mod Shady, Alan, Paige, France, Akil. We are up to 75, Michael. You guys just continue to amaze me. You're, as Michael pointed out with regards to his channel, and I'm so happy we were able to port a lot of this community over to him. But you guys are the best. I sincerely mean that. On behalf of Michael, I mean that as well, because I know you guys support him too. And like I said, this means a lot to me. You guys are the reason why I get up at dark 30 and work my butt off to do what I can do for you guys. It means a lot. And it's just really appreciated. Let's change it up. Let's go to Judge Anzalone. She's doing sentencing this morning, and we haven't seen her in a while, so let's go there.
Ms. Smith. Ms. Smith is present in person. Go ahead and have a seat. Mr. Murphy, make sure the microphone is pulled in front of her. So, Mr. Murphy, you received a copy of the pre-sentence report?
Yes, Your Honor.
All right, and have you had an opportunity to review that with Ms. Smith?
I have, Your Honor.
Ms. Smith, you've had an opportunity to read and review the pre-sentence report? Yes, ma'am. You've had an opportunity to discuss it with Mr. Murphy? Yes, ma'am. You're satisfied with Mr. Murphy?
They not freaking.
You've had an opportunity, I'm sorry, are you satisfied with Mr. Murphy as your attorney? Yes, ma'am. Okay. All right, Mr. Murphy, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
Your Honor, I just wanted to clarify, Ms. Smith believed, and I was looking through it, I think she is currently on medication. She does have a mental health issue. I don't know, she believed that maybe it said that she didn't have a history of mental health issues, but she doesn't. She's on medication for it now. I just wanted to clarify that. I couldn't find in the actual thing, it where it says that she doesn't have a past history. I did say that I did see it said on, where was it? On the evaluation and plan, it says the defendant denied any physical health problems and is not taking any medication at this time. I believe she is taking medication for mental health.
She provided that to MDOC. All right, so we will have someone update that information for her once they get that information from her. All right, does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defects? She has 28 prior misdemeanors and 8 prior felonies.
No, Your Honor.
The probation department has calculated the minimum sentencing guidelines to be 5 to 23 months. Do you agree with that computation of guidelines?
I do, Your Honor.
To show her, okay, for jail credits, 97 days. So is there anything you'd like to say on behalf of your client?
Your Honor, I'd ask the court to consider, a jail sentence less than a year that's recommended, maybe 6 months, or credit for time served. But I mean, obviously, the guidelines here are 5 to 23. A 6-month sentence would be within the guidelines. But I do believe, in regards to Ms. Smith, she is trying to address. She does have, again, she has seizures. I think the medication was for that we were referencing. That had stopped her from getting into rehab before. Your Honor, she has got a very substantial substance abuse issue, as it says in the pre-sentence investigation report. She has struggled to address that. Quite frankly, I understand the necessity for some incarceration, which is why, she has been in jail now for 97 days. I think if the court was inclined to, I know, again, the last time that she tried to go to an inpatient rehab, there was an issue with her seizures, but I think those are under control now. Again, maybe not a year of incarceration, maybe credit for time served and released to an inpatient, or 6 months in jail as a complete resolution. I understand that, this does involve her. It is quite frankly a felony that has quite a substantial past criminal history. But the victims in this matter, they didn't come in, they didn't say there was substantial mental health issues from this incident. Not trying to diminish what had happened. I'm just, obviously there was a grade that we can see in regards to offenses, and I would say this is not the most severe offense that you would look at the situation. She has apologized for her behavior. When she did come in contact with the court, she was trying to get the case resolved as soon as possible. She was trying to take responsibility for it. So I would ask the court to consider maybe not the full 1 year incarceration, something less than that. Thank you, Your Honor.
All right. There's nobody here that wishes to speak as a victim, is there? No. And Ms. Smith, anything you want to say on your own behalf?
I just want to say that I'm sorry to my family, to you, and to the place. Like you said, I do have a severe mental health issue and severe substance abuse issue. And I ask for mercy from the court.
In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for the law, and protection of society. Key there is deterrence against repetition by you. You have like 36 offenses of stealing from people, and you've been in prison, right?
Yeah.
And I know you have, I don't have it documented, mental health issues and or other issues, but I mean, it's just over armed robbery, retail fraud, false information to a cop, larceny, false info, stolen property, retail fraud, larceny. And I mean, it just, your steady progression, worse and worse offenses. So, sense of the court that you'll serve 1 year in the Lenawee County Jail. I'll give you probation for a period of 3 years. Where do you live?
I was living in Toledo, but I have an address here now. It's 53.
I don't want it right now, but I'll give you 3 years probation, 1 year in the Lenawee County Jail, give you credit for 97 days. There's a crime victim assessment fee in the amount of $130, $68 or a $60 DNA fee, but I don't know if you'll have to pay that because I'm sure we just got DNA from you not too long ago. $68 in state costs, $750 in court costs, $30 per month supervision fee, 60 if we have to put you on a tether. 130 crime victim rights, $68 in state costs. I'm gonna put you on probation to try to get you the services you need. I mean, it's up to you at this point. I can't see the next time you're not gonna go back to prison. You understand? Because I mean, I don't know that there's much more plea bargains you're gonna continue to get with your record. So we'll try to give you the help.
Jail and 3 years probation.
Huh?
So I'm getting a year in the county jail and 3 years probation.
Well, yeah. So it doesn't, it's not 4 years, it'll be 3 years, so. You do have the right to appeal this sentence. My bailiff's gonna hand down to you your notice of right to appellate review. I'm gonna initial and date one copy for our records, the other copies are for your records. If you wish to appeal the sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. Mr. Moore, is there anything else?
Just that upon her release, I mean, she'll be contacted by the agent prior to that, but anytime released from jail, you'll report the following business day to the probation department.
All right, so Ms. Smith, I mean, Ms. Walsh is very good about working with people, make sure they have resources. So if you work with her and continue to seek those services, she'll work with you really well and hopefully you can get to a better place. All right, thank you. Dr. Glad to see that signed copy of the notice of right to appellate review. All right, Miss.
Let's go back to Miami-Dade. They've crossed the lunch hour now, and this judge is still going strong. So I'm curious if she's getting grumpy like Judge Glazer, or if she's still hanging in there. Let's find out.
He's not on any kind of bond. He just closed out these cases like less than 2 months ago.
Correct. He's got nothing open.
All right. Where do you live, Mr. Escuero?
It's 3711 Southwest and 27th Street.
Okay, but who lives at 3280 Southwest 7th Street?
I used to live there.
You used to live there?
Yeah.
This is, okay, so how long have you lived at the recent address?
Like a few months. It's just a roommate.
Do you have anybody that they can, if I refer you to pretrial services with the alternate bond, do you have somebody, a friend or family that can confirm your address, sir?
No, not right now. No,
If
I
you're
don't- I don't have family here. I have my son, but I don't live with him.
Okay. Yes, Nessa?
Right, so if your owner's inclined to do non-monetary release, I think TAP would be better than pretrial.
TAP with alternate bond? $1,000. We have to reset this on for TAP or no?
We can give him notice of his next court date, which is July 28th, and it's in front of Judge Brinkley.
And
Judge, I'm sorry.
Brinkley, got it. Okay, I just didn't hear that last part. Okay.
And Judge, do you find probable cause for simple petty theft?
You're right, because it doesn't say, thank you for pointing that out. So the alternate bond would be $100. Okay, not 1,000. So it's TAP with alternate bond, $100. Thank you. And there's a stay away order. Mr. Escudero, if you're released, you cannot go near this Milan's Market, okay? They don't want you anywhere near there. If you do, you're gonna get rearrested, okay?
Okay, Your Honor. Okay, understood.
Okay. All right, Luis Alfonso. Luis Alfonso. Is this Mr. Alfonso? Do you speak English, sir?
Little bit, but I need a later.
Pardon me?
Little bit, but I need an interpreter.
Okay, you need an interpreter. We have an interpreter here. Tenemos un intérprete, señor Alfonso. Let Mr. Alfonso know that he is accused of having committed the offense of possession with intent to sell a controlled substance, methamphetamines, which is a second-degree felony, and 1 count of possession of cannabis.
Señor Alfonso, usted se le acusa de posesión con intento de venta de metanfetamina. Es un delito mayor de segundo grado. También se le acusa de posesión de marihuana.
All right, however, he has a hold. There's an AC that was entered in case number F256117 out of Division 21, so he'll be held on that case until he's able to go before that judge.
Más sin embargo, usted tiene una orden de retención por un delito mayor de este año que usted tiene ante otra división. A usted, o sea, a usted lo van a retener hasta que usted pueda ver a su juez o a la juez el lunes. Your Honor, you also have apparently a mother named Deborah Negron. She says she has a minor here. I didn't know it. D'Angelo Gonzalez.
Not sure.
I don't think so.
Okay. All right, any argument on this? If not, I'm ready to make my findings.
Argumento alguno, porque ya su señoría está lista a dictaminar.
No PC argument, Judge.
All right, on count 1, it's going to be the standard bond, $7,500, count 2, $500. And the hold on.
Su abogado de oficio no tuvo argumento en contra de motivos fundados. Su señoría está estableciendo fianza en la primera acusación, $7,500, segunda acusación, $500, más sin embargo lo van a retener hasta que usted pueda ver su juez o la juez de división el lunes.
All right, next case is Rafael Alemán.
Let's go back to Texas and Judge Stevens.
In summary.
Yes, Your Honor.
In summary, sir, this indictment alleges that on or about September 7th, 2019, in Jefferson County, Texas, you committed the state jail felony of unauthorized use of a motor vehicle. Do you understand what you're charged with? Yes, sir. If convicted, you face confinement in a state jail for any term of not less than 180 days or more than 2 years. In addition, you may be assessed a fine not to exceed $10,000. Do you understand? Yes, sir. Yes. Yes, sir. An agreement's been reached, you would be pleading guilty and placed on, sentenced to 2 years in the state jail. That would be suspended. You would be placed on regular probation, which can be up to 5 years in length. Restitution is owed in the amount of, is it $300?
That's correct, Your Honor.
To the complainant in this case. Is that your understanding? And there will be terms and conditions of probation normal and customary to this.
Okay.
Charge. If I follow this agreement, you have no right of appeal of your case. Do you understand?
Sir.
How do you plead to this? Guilty or not guilty? Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes,
I show you what's marked as State's Exhibit 1. Did you sign that document voluntarily?
Yes, sir.
Understand it, discuss it with your attorney, or the contents true and correct?
Yes.
State's Exhibit 1 is tendered into evidence.
No objection.
Without objection, admitted. Among other things, the state you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. And you were totally satisfied with the representation provided by your lawyer. All of this is true, so help you God.
Yes, sir.
State's Exhibit 1, part of the record for all purposes. Is pre-sentence report waived in?
Yes, sir.
I am going to follow this agreement and find you, sir, pleading guilty today voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt here. I now find you guilty beyond a reasonable doubt of this offense. I am following this agreement, and you are hereby sentenced to confinement in the state jail for 2 years. That will be suspended. You were placed on regular probation for 5 years. And there will be terms and conditions of probation, which are normal and customary for this type of offense. Make sure you follow these.
Yes.
If you fail, your probation can be revoked and you can be sentenced up to 2 years in the state jail. And restitution is ordered in the amount of $300 to the complainant in this case, when can you pay that money back?
As soon as possible. I'm on disability, so I get paid once a month.
Okay, yeah, well, you get that paid as soon as possible, okay? And it has a lot to do with how long you're gonna be on probation, you know what I mean? You get rewarded, by doing well.
Okay.
Okay, we can shorten it. All right, please see the probation officer. Oh, she needs your fingerprint first. Thank you, sir.
You go have fun. Straight up and down in 95.
Let's head north of his position. We'll go to Kansas and we'll see what's going on with Judge Webster.
The alternative A2, is A1 the only argument you're going to be making?
A1 is knowingly or recklessly. So we were going to argue for the recklessly, Your Honor.
Well, it's also causing bodily harm as opposed to physical contact in a rude, insulting, or angry manner. I just wanted to make sure I applied the right standards for what you're charging.
Yes, recklessly involves recklessly hitting or touching the person.
Okay.
Because recklessly is not included in A2. It's knowingly causing physical contact.
Right, but causing bodily harm is required in 1 where not in 2, just rude and insulting. But it's your case and I will listen to your argument and proceed from that point. Thank you.
We'll add alternatively A2, Your Honor. In this case, the children saw it. Obviously, the youngest one especially said she saw it. The older one in the video says she was upstairs, but the little one was downstairs. She saw it. She saw Colt hit mommy. Those are her words. Colt hit mommy. As Deputy Hansen was coming up on the porch. And then when he gets in the door and the girls are talking about it, the older one says she was upstairs. The younger one was downstairs and saw it. Just showed how the door was slammed. The victim initially says he choked her around the neck. Then she tries to change it to shove her in the chest. As it moves on through time, she admits he hit her chest, and today she's trying to change it because she wants to be with him. At the scene, while the officer is outside, she comes out and says, he just told me that if he goes to jail, I'll never see my keys again. I don't want him to go to jail. I need my keys. The control and the trying to get her to change her statement and not have him go to jail starts at the scene. It continues. He and her went to Dr. Machadas together and turned over some information to say they didn't need BIP and they needed to be together. It's continued that she wants to reconcile with him or have him back in her life and back home. In her letter, she admits that it's a financial issue that she wants him home for. But at the time that she is making her reports, there is ancillary and collateral evidence that shows that he shoved her in the chest, that he hit her with the door and knocked her down. Even in her own letter, she says, he pulled open the door, which had hit me, making me fall backwards. I then went back to shut the door again when Colt stuck his hand out to stop me from shutting the door again, his hand placed between my chest and chin. I know that she's trying to minimize what happened because she wants to reconcile with him, but this is Mr. Gordon's 4th domestic battery in less than 5 years. She, during the incident, describes many other incidents, including a black eye at Christmas, and multiple other incidences against her. Her family's like, we're not stupid. We know this is happening. Her own mom says, we can't help you till you want to help yourself. Believe that he has committed domestic battery against her in this incident, using the keys to control her and to restrain her to the house, knowing she had an important appointment. We'd ask the court to bind him over on the felony, having the prior convictions in the prior Greenwood County cases.
Thank you. Mr. McClendon, any argument?
Yes, Your Honor. Addressing the statute specifically, the contact has to be knowingly or recklessly. I don't believe, and Ms. Tavia's statement backs this, but this definitely wasn't knowingly, and I believe given the context of the situation, I highly doubt it was recklessly. And if you're going to consider A2 as well, I don't believe it was done in a rude, insulting, or angry manner. I believe there was a fairly hostile situation between the dogs and stuff, trying to get them out of, or keep them in the house or out of the house, or whichever it may have been. And there was a closing of door. I don't believe that contact would constitute domestic battery here in this case. Additionally, Judge, we are not to use their prior convictions against them. They are purely for the purpose of establishing that this is a felony charge. Even though it is a pattern, we're not supposed to use that pattern. And I know you know that, but just to put that on the record here. Additionally, Judge, I think Ms. Tavia's statement here today would show that the passion was high at the time, but now that she's had a chance to reconsider what actually happened, this may have been a false report, and she is aware of that. And that's all, Your Honor.
All right. Well, thank you, counsel. And you do correctly state, Mr. McClendon, that the prior 3 convictions within the last 5 years, each for domestic battery, are not to be used as evidence of guilt for purposes of preliminary hearing or for meeting the elements. But the way this charge is written, it did say A1 of 215414, but the language also included 2 when done in a rude, insulting, angry manner. And it does include a little bit of both, not all of both or either. That's why I wanted clarification that he is being tried under A1 as well as A2 or alternatively. And I believe there is probable cause to believe that the defendant did knowingly or recklessly cause bodily harm, slamming the door. There was some talk about marks, her neck. You don't accidentally put your hands on someone's neck. You don't, in this instance, accidentally slam a door. Or if you do, it's in a reckless manner. But there is probable cause to believe, certainly as well in A2, that there was physical contact, the defendant against the alleged victim, and it was done in a rude, insulting, or angry manner. So I am binding the defendant over on violation of domestic battery. I do take judicial notice. I've looked up those cases that give the basis to the felony. 2021 CR 233 does include amended count 3 domestic battery. 2021 CR 207 does show conviction for count 1 domestic battery. And 2021 CR 23 also shows conviction for count 1, domestic battery. All of these occurring in 2021 as far as the occurrence date. The journal entry of conviction also being filed in February 1 of 2023. That is within 5 years. So the defendant is bound over on the felony domestic battery. Missy, who will his arraignment be in front of?
And this case goes to Judge Satterfield, and she is available July 17th at 1 o'clock.
July 17th at 1 p.m. I presume that Zoom will be okay?
Yes, by Zoom.
All right, so Mr. Gordon, I'm going to continue your bond with all of existing conditions and the added condition that you reappear with counsel July 17th at 1 p.m. for arraignment, at which time you'll be asked how you plead to domestic battery after 3 prior convictions in 5 years. Now, as I say, continuing that bond, I am not granting the request made by the alleged victim to lift the no contact. Now, the contents of her letter that was admitted as an exhibit today implies that she knows all about what's going on with Mr. Gordon, and she's right in the middle of it, which suggests maybe you have been having contact with her. You are not, as your bond says, to have contact with her. That means in person, in writing, through a third person, any third person, no social media. And Miss Mitchell, you understand that if you have contact with him, you are putting him in the position of having his probation revoked and having him stay in jail until this matter is resolved.
Yes.
So be mindful of that. Also be mindful of any effects that your children might be having. Subjecting your children to ongoing behavior like this could involve DCF in your life to protect those children. So make sure that you protect your children so the state does not. And make sure you honor his bond so he does not have to go to jail. And I understand that a person in a domestic violence victim's role has a lot of complex issues going through their mind, and therapy can help. But you are a witness for the state, so you and Miss Gillette want to talk about some of that for your sake as well as your children. But the bottom line is simple, Mr. Gordon, you are the one on this bond. You are the one that can get your bond revoked. You are the one that can sit in jail. So if she should call you and want to talk to you, you keep that in mind. And you can talk to your attorney about that further. Anything else we need to address, Ms. Gillette, from the state's perspective on this matter?
No, Your Honor, thank you.
You're welcome, Mr. McClendon. Anything else we need to address from defense?
No, Your Honor.
All right, thank you. Thank you all. Deputy Hanson, thank you for your time. And this hearing is adjourned.
Thank you, Judge.
You're welcome.
So Pepto Jr., an early happy birthday to you. I hope you do have a good birthday tomorrow. Bringing up the whole concept of not having live on the weekends. Not a lot I can do about that, as I just said in the chat, other than some first appearance courts. There's not really a lot to work with. But I don't know if it's going to happen this weekend. Probably not until next weekend. But on Sundays, very soon, again, this weekend if I can pull it off, probably the next though, we're going to be doing a best of stream on Sundays where we'll pick 1 or 2 great court interactions that happened during the past week, and we will show them off. So as I'm talking, Judge Webster decided that she was done. Let's go to Well, let's go to the dungeon. There's honestly not a lot to work with today, but that's all right. We always have the dungeon to fall back on Fridays.
You've seen the report, Mr. Murphy?
Yes, Judge.
I'm kind of at a loss. I don't know what to do. We've tried a lot of different things, and at times it seems like we're making progress, but then there's always a problem.
No, I promise being found in wrong rehab, I will do my best. It'll be the same. I need treatment. I realize the job I would get when my disciples and my anything, and that's what I need. I need treatment.
We can't be on the roller coaster anymore.
I understand. You're correct. No, I have one more problem. I mean, at the same time. I mean,
Well, do we have a bed for her anywhere?
I'm sorry, sir, but
I asked if there's a bed available for you anywhere.
I know that Lawrence County Recovery Management agrees. I don't know if UCC or hometown is available. Your Honor.
Okay, she's gonna need, I believe, mental health counseling also.
Providers indicating yes, Your Honor.
Anyone that thinks they're interested, you can call the jail, talk to her. Another suggestion I might have would be, I mean, you've been in the breeze before, haven't you? Have you been in the breeze previously?
No.
I don't know if they have any beds, but, okay, we'll see what's available and come back to you later in the docket.
See you later, Doc.
Yeah, we'll see you later today. We'll try to see what's available.
State of Ohio versus Heber or Edward J. Medina, and Logan Wright is on deck.
So, the representative of Bethesda, he can kind of be the go-between and try to help find a bed for Carrie. Carrie, appreciate that. Mr. Warford, you can get your input in there too.
Yes, please. I'm gonna call and talk to her today.
Okay. All right, Eber Medina, that's you, sir? Are you Mr. Medina? Okay, is your audio not working? Can the jailer hear me?
Audio check.
Okay, I can hear you.
I hear you on the headphones.
Okay, all right, thank you.
Probably doesn't speak English.
Okay, Your Honor, I believe we may have to call a translator for him, realizing it's speaking.
Okay, we'll do that later.
Okay, thanks, sir.
Well, they find somebody in the netherworlds that speaks the language of the defendant. Mao, you want to come over here and say hi? Come here. Uh-oh. You hit a button. Oh. You messed up what I had lined up. Now I got to refigure it out, sweetheart. All right. Everybody's got to wait a minute now because Ellie just messed up what I had queued up. Cute and destructive. All right. Well, the heck with that. Let's go back to the dungeon court while I fix everything. Thanks, Ellie.
Was released to us from Waldo's, and the holder was just from here.
Okay, so,
We have a bed waiting on him.
And you're from which facility?
Southern Hope.
Southern Hope, okay. So Southern Hope is here saying that they're agreeing to take you into treatment. Is that what you want to do?
Yes, sir.
Okay. So that's just down the street here from us. So I'm going to release you to go to Southern Hope for treatment. And I'll set another hearing for you. July 21st for a review hearing at 9 o'clock. So
Yes, sir.
bring for a review then, July 21st,
At what time?
9 a.m.
Yeah, okay.
So I'll enter an order releasing you to Southern Hope today.
Yes, sir. Thank you, sir.
State of Ohio versus Heather M. Webb, case number CRA 2561.
All right. Ellie says she's sorry. Let's try this again. Judge Stevens.
Yes, sir.
And you were here with Mr. Grove. You were charged with the second-degree felony of assault on a peace officer. If convicted, you face no less than 2 nor more than 20 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand?
Okay.
All right. This is announcement. What are we announcing?
Well, Judge, basically, I believe the prosecutor and I have worked out an agreement where this case will be dismissed against
What does she have to do?
She has to
Go through
basically get in the Army, Navy, or one of the branches of the service. The case is supposed to be dismissed, and then if she is not entered into the service within 180 days, the DA at their discretion can come back and can be fined.
180 days from what date?
Well, and Your Honor,
When did that start?
There's a proposed agreement here by Mr. Groves, but I informed him that he'll have to present that to, it's essentially looks like a type of pretrial diversion. He'll have to present that to Mr. Canal upstairs for his approval if he's approving it.
Okay, what do you want to do to this? Review it in 60 days?
Yes, sir. And I think that I think we're pretty.
All right, we'll
close
review it
to
in 60
getting
days.
done. Yes, sir.
Okay. Review in 60 days, get a resetting, please.
Next, sir.
Huh?
So review.
Review. You're going to come in and we're going to find out everybody's going to tell me what the status is on the case, what direction we're headed in.
Okay.
Okay. Please, and Erica Joseph is in jail. Keelan Maldonado, come on up. Mr. Maldonado, in 24 CR 2392. You're charged with the first-degree felony of aggravated robbery, sir. This is very serious. You are looking at up to life imprisonment, sir. Okay, how old are you?
18.
Judge, what we have here, we have a plea bargain agreement, cap here, where Mr. Maldonado may plead to the court, and the court could give him probation or send him to TDC. I left him up until the very end. I said, do you want to take the plea, which would be a cap plea, or do you want to set the case for trial? And that's where we are right now.
Okay, what are we going to do?
Yes, sir. I was trying to see if I could get the first probation.
That's, you talk to him. That
We've
would be, if there isn't, he's talking about a cap that gives me options, and that would be one of the options, but it would be up to the court to determine. But That would only be after you entered a plea of guilty and after a pre-sentence report was completed. Then we come together, I read the report, everybody adds any additional information they want me to consider. And then I make the most intelligent decision I can make with the information given to me. That's the way that works. The other side of the coin is you can go to, and try it in front of a jury. Those are your options. So what are you gonna do?
And I believe that Mr. Boyd has made a cap offer, but it is discretionary with court, what the court wants to do.
So what do you want to do?
And what I have tried to tell Mr. Maldonado is that the DA will not agree to either a deferred adjudication or regular probation recommendation. The court can, and that's what the offer is.
Okay, so what do y'all want to do?
You want to
or try the case?
You want to try the case? You want to go ahead and take the cap where the judge could give you probation or deferred adjudication probation, or he could. But there's no guarantee that it will be a deferred adjudication or a regular probation. It's just it could be. And this is the same offer we've had for a long time.
Yeah.
So we need to decide what you want to do. If you want to do it, we can do that today, or the judge can set your case for trial. And that's the other alternative, which I don't think he wants that, but it's the other alternative, I believe, Your Honor. So what do you want to do?
Don't sit for trial, so.
You want to go ahead and plead guilty to the judge and ask the judge to give you probation in some form, either regular probation or deferred adjudication probation. The judge will take care of that if the court would give.
All right. There you go. We'll do that today, write it up, and then we'll have a pre-sentence report prepared, which would take a few weeks, and then we'll all come back and put in whatever additional information you want me to consider, and then I'll make my choice, my decision.
Yes, sir.
And we'll move on with our lives. Okay. Fix that. Erica Joseph is out. Just have a seat right there, sir, and he'll get back with you. Greg. Thank you. Erica Joseph is next call. She's in jail, 18-29479. That's a motion to revoke uneducated probation. What are we going to do? You okay there, buddy?
Yes, sir.
All right.
Miss Joseph is on
yes
probation.
Then we have a motion to revoke probation.
She has been given an offer, a cap offer from, I'm sorry,
Of 8 months state jail.
8 months state jail. She also is on a state jail caseload. What she tells me, she does not want to take any kind of a plea bargain.
Okay.
She wants to let the court leave her on probation.
Well, yeah, that may be what she wants, but it'll be the court's decision based upon the evidence. There's a motion to revoke unadjudicated probation. Are y'all ready to move today?
It's all administrative, Your Honor.
Showed the presence, failing to abstain. Okay. What do y'all want to do today?
Do you want to ask the judge to leave you on probation?
Yes, sir.
You got to be pleading guilty. You got to plead true to this first, right? I mean, we got to go through this hearing first. Now, y'all are going to the sentencing phase. Well, first of all, she's presumed innocent. There's a motion pending, and this has to be proven. Then we go to the step on what happens if it's proven true.
Judge, it's my understanding that if she wishes to plead untrue and wishes to stay on probation, she has that option. So that's what I think she wants to do.
Is that right?
I plead true. But
Okay, have a seat. Let's go. We'll work on this. We'll do this. It's contested. We'll work on it. And
Can we take her formal pleas, sir? Just so that we can.
yeah, I'm about to do that.
Okay.
I'll do that. But everybody have seats, and we'll go from there. All right, 18-29479 is called the State of Texas versus Erica Marie Joseph. That's you, ma'am?
Yes, sir.
Present with Mr. Grove, your attorney, and the state's attorney. There is a motion to revoke unadjudicated probation that has been filed as of April 11th of this year. Does the defendant waive a formal reading of this motion to revoke probation? Mr. Grove, can we proceed in summary?
Yes, Your Honor.
And raise your right hand, ma'am. Do you solemnly swear or affirm any statements you make during this hearing will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
Lower your hand. In summary, this motion to revoke unadjudicated probation states that on September 24th, 2018, in this court, you were placed on 5 years deferred or unadjudicated probation for the crime of injury to a child. And that was the indictment which alleged that you, on or about February 12th, 2018, in Jefferson County, Texas, recklessly causing bodily injury to a child not older than 14 years of age by throwing a can at or near the child, striking the child in the head against the peace and dignity by the state. Is all of that true?
Yes, sir.
All right. And allegation number 1 states you provided a urine sample to the probation office on or about March 13th, 2025, which showed the presence of benzodiazepines and tetrahydrocannabinol, which are violations of condition 10 of your deferred probation order. And the condition 10 states do not use or possess any drug, use of, possession of, and prescriptions for any and all medications must be immediately disclosed to your probation officer. So do not use or possess any drug. You understand what you're charged with in allegation 1. Is that true or untrue? Is this allegation true or untrue? Are you pleading true voluntarily and because it is true?
Yes, sir.
Do you understand that a plea of true to 1 or more violations of probation, that would be enough to grant the motion to revoke probation? A voluntary and knowingly made plea of true is enough to grant a motion to revoke probation. Your probation could be revoked. You could now be found guilty of this state jail felony and sentenced to no less than 180 days up to 2 years in the state jail. Knowing that, do you insist on pleading true today?
Yes, sir.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true. Allegation number 2 states you failed to abstain from the use of any and all intoxicating substances, including alcohol, in that you provided a urine sample on or about March 13th, 2025, which showed the presence of alcohol. So apparently that same test, that same analysis or sample that you gave, which showed drugs, also had alcohol in your system. And that is what they're alleging was a violation in allegation 2. Is that true?
Yes.
Are you pleading true to that allegation voluntarily and because it is true as it is alleged?
Yes.
And you understand the consequences that can happen of voluntary and knowingly pleaded true to 1 or more violations of probation? That's all it takes to grant a motion to revoke probation by a preponderance of the evidence or greater. Your probation can be revoked. You can now be found guilty and sentenced up to the full range of punishment we described. Knowing that, you insist on pleading true to this today.
Yes.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true. Finally, allegation 3 states you failed to pay court costs and assessed fees as directed. As of March 18th, 2025, you were in arrears $2,738, which is in condition 28 of your deferred or adjudication order. And that states pay the amounts shown in this order. And that is a fine of $500, supervisory fees of $60 a month, attorney's fees $600, Crime Stoppers fees $50, post-sentence investigation fee $500. It all ends up adding up. But anyway, were you indeed in arrears at that time?
Yes.
Were you able to pay these?
No, sir. I work.
I work at KFC, I'm a shift manager, and I pay child support to my children, because since this has happened, my children have been removed from me. And my son is now 19.
Yes,
To
ma'am.
get him into college and stuff, trying to get him into, doing something positive with his life, because he lost his father at the time that this happened.
Okay.
And I was going through depression.
Yes, ma'am.
Anxiety and depression.
Okay. But what you're saying is, you okay there, David? All right. You're in arrears on these payment requirements, but
Yes,
you would have paid them had you had the money,
yes, sir.
but you didn't have the money.
No, sir.
Okay, well, then we're not going to enter a plea on that one, okay? Because nobody goes to prison for being poor, okay? You got to pay what you can.
Yes, sir.
This isn't debtor's prison. Those are bad things from history, and we don't like to even think about that. And America is not that way. All right. But you've got allegations 1 and 2 here that you need to deal with. And you're talking about all your responsibilities. I can appreciate that. But you're talking about drugs and alcohol that have nothing to do with responsible behavior, especially when you have so much to lose here by following the rules responsibly, or if you fail to follow the rules. And that means not using drugs or any of the children at all in your home?
No, sir.
No.
They're all with their paternal grandmother.
Okay. Is this lady? Or is this the other?
That was the last time.
Okay.
I'll get you.
Yes, if you can. All right. What do we want to do?
I have the probation officer here if you want to hear some testimony about.
Well, I'm curious what y'all want first, and then she has 138 days credit. Okay. What do you want? Do y'all want to call somebody and to the stand, or do you have any ideas where y'all stand on this? I think David Grove, you're going to want to continue her on probation.
Yeah, sure.
I presume.
That's
Okay.
what she indicated.
Okay. What's the state asking?
Seen for 8 months state jail. We've had several issues with her in the past. She's been to Safe P. She's been to Safe P Relapse. She's done the drop program. She had outpatient help as part of Spindletop, and she continues to test positive on drugs. So at this point, I believe that probation has exhausted all efforts on this defendant. We think 8 months state jail is fair, considering her lack of ability to stop her drug use and her alcohol use, and the fact and the underlying offense of this case.
Okay. You want to call somebody to the stand then?
Yeah,
Okay,
we
go
will
ahead.
call Dominique Mayfield.
Dominic Mayfield, please come forward. And raise your right hand. You solemnly swear or affirm the testimony you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Thank you, ma'am. Go ahead. Have a seat. Stand by. Let me look at one thing here. You've been the probation officer for this land?
Yes, sir.
Because I was looking at Douglas Gregory was a probation officer at one time.
Yeah, she had completed the safety continuum and then she was placed on the MHI, which is the mental health initiative caseload.
Okay. Stand by. Stand by. Okay, Ms. Mayfield, is your witness? Go ahead.
Are you currently the probation officer of Erica Joseph?
Yes.
How long have you been her probation officer?
About a year.
Is she in the courtroom today?
Yes.
Could you point at her and identify an item of clothing that she's wearing?
Yes, she's in orange tights.
May the record reflect she's identified the defendant.
Yes, it will.
Has Miss Joseph had more than one administrative hearing?
Previously, before I had this.
How many administrative hearings has she had?
Counting 3.
Yes.
Going back to 2022, what this court shows is on June 21st of 2022, it was alleged that she had tested positive for drugs, cocaine, benzodiazepines, and that it stated she tested positive for illegal drug use on 5 separate occasions while under supervision. And this was before June 21st of 2022. Again, the defendant had been on probation since September 24th of 2018. So this was 4 years into her probation. She admits she has issues with substance abuse, minimizes though the extent to which she uses. The defendant has attempted to assist her in overcoming her addictions by referring her to Spindletop ATAR, but she has refused to actively participate. Defendant is also a participant in Spindletop forensics program, and her caseworker concurs with this officer that the defendant is in need of a more restricted inpatient program. So they were recommending entering into completing the special needs substance abuse safe P and extending the current probation for a period of 12 months. And this was approved by the court on 6/20, looks like 6/27 of 2022. Did you go through with that program? Yeah,
Yes, sir.
you did that. Okay. So that was in June of 2022. Then in May 29th of last year, I get another administrative hearing from Ms. Joseph. And this one states that the defendant tested positive after the Safe P program for THC and alcohol. And this would have been on before the most recent, the one we're dealing with now, the tetrahydrocannabinol and marijuana again. So you had completed Safe P, then you were sent to Safe P residential aftercare at the Middleton Center on June of 23, successfully completed that. Then placed on the Safe P outpatient on 2023, and you completed that on April 22nd. You have struggled, it stated back then, with substances. And you were also testing positive for alcohol. And you reconnected with Spindletop to resume your mental health medications and thought that would help you. And this states you do have the tools to stay sober, but you don't have the commitment to be successful. So it was recommended that you enter and complete drug rehabilitation, the DROP program, and placement in the mental health initiative, which this court granted on June of 2024. Did you do that? Yeah.
I'm not aware of what this is.
And I granted that. What happened on that?
The drop program is when she would be placed on the color and she would come in, she would call the,
And that was done.
Okay, yeah, I know that I did that after I came back from Safe P.
That was the second thing. That was the second set of help that we gave to you, you know.
Oh, I thought that was just part of the aftercare from Safe P.
No, we had a hearing on this and I didn't order a revocation or anything like that because I'm trying to give you all the help you can.
Yes, sir.
Okay, now we've got a third situation. Miss Mayfield's administrative hearing shows up to my desk on March 18th. This is the third.
Yes, sir.
And this states that you tested positive for benzodiazepines and THC and failed to abstain from alcohol. You have struggled to come into compliance and you have been consistent in the illegal drug use.
Yes, sir.
Hold on. The department has attempted to assist the defendant in living a clean and sober lifestyle, and they have. They're doing their part. In addition, while on the mental health initiative caseload, in conjunction with Spindletop, you had been receiving outpatient substance abuse programming. Yet you continue to use illegal drugs. The officer believes this department and the court have exhausted all available resources at their disposal to aid in your success, as you lack the ability and or desire to be successful on probation. It should also be noted that your probation was continued for 2 more years, which this expires in September. And the recommendation was to file a motion to revoke probation, which you did not agree with. This court followed the recommendation of the probation officer. And then this motion to revoke unadjudicated probation was filed on April 11th of this year, which alleges what you have pleaded true to in allegations 1 and 2. And that's where we are. I think it boils down to this, everybody. Has she had more than enough fair opportunities to fix her problems or not?
I turned myself in to the officer.
I know what we want you to do is refrain from illegal drugs and alcohol, ma'am.
Yes, sir. So I did two months in county so far.
You have 138 days credit.
Okay, yes, sir. Thank you.
But remember, this is a state jail felony. The minimum punishment is 180 days, 6 months. And this is 138 days showing, which is, a little over 3 months,
Yes, sir.
3.5 months. But you're at the minimum, see that you're still 42 days away from a minimum sentence. Anyway. Are any children at home?
No, sir, they're not at home with me, but I'm helping my son get into LIT right now.
How you doing that?
Filing for his FAFSA, and he's going through the Pittsner Foundation where they're helping him also. And he's he's at LIT right now, and I need to file for his rest of his financial aid assistance so that he can continue his.
All of this is good. You're helping your son. That's what a responsible parent is.
Yes.
But also a responsible parent, the most important thing is being a role model. You have to set an example. Why shouldn't he use drugs? You're doing it. Where's the role modeling?
I don't do drugs around my son. He don't really.
That is the most pathetic thing I think I've ever heard.
Yes, sir.
That really almost tops the chart of the most weird things I could hear from someone. You really think just using illegally drugs in secret is the right thing?
No, sir. I use my thought stoppers also to not, continue.
You're taking, ma'am, this is the 3rd time you've tested positive.
Yes, sir.
But I think you're missing the boat here. This is your life. You're the role model. And don't think your children can't see problems. But you got to admit and face the fact you're making consistently the wrong choice. And we've done all we can to help you, I believe. And you're still, these are crimes.
Yes, sir.
On the court's watch. My
Yes.
goodness.
It's one more thing that I signed for to do through the probation, if you don't mind, Your Honor.
Go ahead. What?
It's the DTS program where I go back on colors and I go to classes at the probation office. And
So how would that help you?
because I'm gonna go to my meetings and I have a new sponsor that I met since being incarcerated at the JC at the jailhouse. She's with Keeping It Simple at St. Anne's Catholic Church, and I want to she's gonna be my sponsor. I met her like about 3 weeks ago.
Okay, so what's different? We've been helping you and getting you in all these uh, uh, substance abuse
Yes.
programs, and you have consistently failed them and continue to misuse.
Yes, sir. Just
So-
ask that you try one more time with me, please, Your Honor. Please, Your Honor.
How would
I
this
just
be
want
different?
one more
How would the
chance.
fourth time be different?
I'm trying to build a better relationship with my daughters and my son, and I will complete this program.
When did that come about?
Actually, my son and my daughters, recently when I came home from safety,
When? Give me a date.
say, September the 4th on his birthday, September the 4th of 2024.
But you're testing positive in March. What is this year? Just a few, you're testing positive. Anyway, after that.
Yes, sir.
So there's nothing there's nothing that has occurred with his situation that made you change. Okay, let's just get it clear.
I just asked for one more chance, Your Honor. Just one more chance to get it right, please, sir. And I will get it right, and I won't let this occur again. You won't see my face again in here.
I wish I had $1 every time I heard that one.
Yes, sir. I understand that you've heard that before.
But you made a promise when you first started that you would. Let me read it. It is eloquent.
If I may, Your Honor.
Hold on, let me read this.
Okay.
This was when you were placed on probation initially, back in 2018. You made a deal with me and you signed it right here. I have received a copy of this probation order. I agree to follow all conditions imposed upon me, and I know that this community supervision can be revoked for any violation. I will remain in the legal custody of the District Court of Jefferson County, Texas, and I hereby waive extradition if I am charged with a violation and am arrested in another state. I agree to follow all conditions imposed. How many times did you break that promise?
Few times.
4 that I know of. And you're asking here, let me hold your wallet, Judge. You can trust me? No, you made a promise there. You broke it in 22, gave you another chance. You promised all would be well. You broke it in 24. All would be well. And you broke it in 25. Which it's the same problems. Drugs and alcohol that we put you through all the programs. But it's not the programs that make the change, it's your will. It's your intestinal fortitude. And we can't force that. That has to be your choice. Okay. What's state asking for?
8 months state jail.
What do you say, David?
Judge, since Ms. Joseph asked to be reinstated on probation,
Yes.
I would defer to her on that.
What would a backup plan be? If you had, what would you request if the court decides not to grant the relief you're asking? In all fairness, you've got to see, I mean, I open the door for one, I open the door for everybody. Everybody is unique, but this is the fourth problem. It's the same problem. We've exhausted what we can do, and all her answer is give me another chance, which would be the 5th, which opens the door for everybody to get 5 chances. I don't like that. Everybody, you made a promise in the beginning.
Judge, I believe, Ms. Joseph will request 180 days.
Yes, sir.
State Shelley. Is that correct?
Anything else? Would you like to say anything, Ms. Joseph? This is your life.
Your Honor, I'm just asking that you show mercy upon me at this time. Just so I can I just want to relationship with my kids and to show them that I can live sober and to do this and to do a sober lifestyle and to be happy being sober. I've been through a lot of depression. The father was murdered. I've lost a lot of family. While being on probation, sir, I've been through a lot of different changes in life. And I know that's a part of life.
Yeah,
And it's
yeah,
just
everybody
difficult
does
to-
it. Everybody suffers.
Yes, sir.
This isn't a bed of roses. But we all have to deal with it in our own way.
Yes.
And wouldn't you agree you've had more than enough chances here to do?
Yes, sir.
It's a consistent pattern of the same mistake.
Yes.
I,
And I'm trying to go through safety and take my medicine and do better.
yes, ma'am.
I'm sorry, sir. I said safety. I meant spindle top.
Yes, ma'am.
Oh, goodness. I'm going through spindle top. I had a little, in between time, I messed up a little bit, but I think that,
Messed up a little bit, those are crimes. Each of those are criminal acts.
yes, sir.
And we've got three sets of criminal acts since you were put on probation.
Yes.
Oh my goodness, it's just that's hard to ignore. And it's the same crime. But yeah, what you're just not accepting is that your life touches your family's life and you're supposed to be a role model. And you can't expect your children not to do the same thing you do. You're setting a consistent example of committing drug crimes. And that's not good parenting.
That's true, sir.
All right. But it's your choice. You've decided this is more important than setting a good example for the children. That's got to change if you care about them.
I love my babies.
You gotta just don't talk the talk. You gotta walk the walk of responsible behavior. All right, I'm going to find, if nothing further, there is sufficient evidence supporting this motion to revoke unadjudicated probation, to grant it by a preponderance of the evidence or greater, as allegations 1 and 2 have been proven true. And your deferred or unadjudicated probation is hereby revoked. In this case, earlier you pleaded guilty voluntarily. You were mentally confident to do so. You understood and appreciated the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt at your guilty plea hearing at the beginning. I now find you guilty beyond a reasonable doubt of this state jail felony of injury to a child. I am following, there is no agreement. You are hereby found guilty of the state jail felony, and you are hereby sentenced to confinement in the state jail for more. And you failed in each of those occasions. Well, you gotta do better, if not for yourself, for the family you keep claiming you care for. Nobody lives alone. We're not on this planet alone. We touch other people's lives, especially our family. And the greatest gift is a good example, a role model. Greatest gift a parent can give, because your children are going to do what you do, and you're not setting good examples. You have to do better if you really love your children like you say you do. You got to commit to that. And every day is a challenge. But we all do. We all are required to do it, or else we get held responsible. Are you able to do it? Are you able to?
Yes, sir, I am.
Well, then do it. If not just for yourself, for the children you care about. Good one.
Thank you.
Yes, ma'am. Anything else?
David's
Maldonado? Yeah, Caitlin.
So that got glitchy there at the end. That was the judge's feed. That wasn't on our end. So I didn't catch exactly what she got. And then the audio and the video were out of sync too. So yeah, I don't know what she got. I asked Megan. Megan didn't know either. So, but I think message was sent nonetheless, and hopefully she gets her stuff together. So Maggie, did you enjoy our little stream today?
I did. It was fun. Thanks for having me.
Oh no, thanks for stopping by. It only took you to your last day here to finally show up, but that's okay. I understand.
Well, you know, Dad, you do start these streams at the dawn of the day, and I'm on vacation, so.
Well, yeah, no, I've just been letting you sleep. It's okay.
Thanks.
But I appreciate you stopping by. And it looks like you'll be back in a couple of months.
I'm hoping so, yeah, and maybe then I can join for another stream. It's been fun. You have such a great community here, and it's really nice to see.
I know you see it now. You understand why I'm putting this much effort.
Yeah.
And your brother and Beth saw it a couple weeks ago when they sat in, and they get it now.
Yeah.
This is special.
It's really truly something special, and seeing everybody today come together and talk amongst each other in the chat and gift memberships to other people to let them join the experience is truly something special.
I agree. So there you go, friends. Praise from my daughter. And even Ellie wanted to come up and be a part of it. So, had enough? Are you just going to lay down, or what are we doing here? So it was 75 gifted memberships today, and honestly, they came in so fast, I'm not 100% convinced that I thanked everybody. So if I missed you, if you gifted something and I didn't catch it, a blanket thank you. As I said the last time you guys did this, it's so appreciated, and it just kind of shows the character of this community and how special everybody is. And thank you, sweetheart. And it's very much appreciated. In the chat, you will now find a link to Michael's channel, or Mike as he prefers to be called. Most of you should know it by now, but if you're out there and you have not run across Michael Groff, you need to go over there. You need to subscribe. He is born to entertain and to educate, and just his voice alone is soothing and worthwhile. Ellie likes it too. Yes. Do you want to talk to the people? Or you just want to love on the microphone? Well, loving on the microphone works too. Okay, so here's what I want to leave you with for the week. Towards the end there was some discussion in the chat about mistakes that have been made in the past by people. So I want to leave you with a little Danism before I go. I look at life as a tapestry, a whole bunch of threads that are sewn together to make something unique and special. But what happens with a good tapestry, if you start pulling at the threads, it all comes apart. And it's very easy for us to look back on things that have happened in our lives, mistakes that have been made, and say, I wish that never would have happened. I wish I... Don't step on the keyboard. I wish I could remove that, stuff like that. I didn't get that feeling from the chat that people feel that way, but it made me think about this, because I always encourage people to not do that. I know I sounded like Judge Boyd right there. Here's what I always tell people. But it's true. I say that a lot to anybody who will listen. Don't ever think about removing the mistakes and the bad things that have happened in your life, because all of that comes together with the good to make you who you are now. And if you start tugging at those things, then what you are now is no more. And I will tell you that what you are now, if you're in this community, I'm convinced of it, you're something special. So, just my thoughts. All right, I'm going to go ahead and leave it there. We will see you all on Monday, 10 a.m. Eastern, 7 a.m. Pacific, half an hour early for channel members. Again, thank you all so much. Your generosity is amazing. Appreciate all of you. But we'll see you Monday. You want to say bye, Ellie? No? Well, I'll say it for you. Ellie says bye. Take care. God bless.